Can each side please let me know if you are ready to begin with the trial today?
Your Honor, the defense is ready to proceed.
And Your Honor, the prosecution is ready to proceed.
Great. And so typically if we were in the courtroom, we would ask each side to provide a copy of the trial roster and the team's code. I see that folks are providing that in the chat function. So if you have not done that already, if you could please just list your team number and your roster in the chat function so that myself as the presiding judge and the scoring panelists will be able to review that. So I have to go through a handful of advisements with the folks here this afternoon. First, since we're not in the courtroom, I don't see any video recorders present, but under the rules, people are only allowed to tape the trial with permission of all parties. So if you are recording this and do not have permission of each side, please stop recording this proceeding. I also need to advise that the Colorado Bar Association during the course of this proceeding may be taking photographs or still shots of the competition here today. And by participating in the tournament, that grants automatic permission to the Bar Association for the use of these photos. I need to ask if there's anyone in the gallery who is connected with teams not competing in this round, and I believe we have teams 2 and 4 here today. Is there anybody present who is not connected with either of those teams? And that would include student members and coaches of other schools or of the same school but a different team. If you could please identify yourselves. With that in mind, if any folks jump into the hearing that you don't recognize or that you believe to be from a team not competing in this competition, please let me know and we'll make sure that they're aware of the rule. I need to remind the teams that there will be no recesses permitted with the exception of those granted for a health emergency. And this is especially true not between the end of witness examination and the beginning of closing arguments. That said, if somebody has a health emergency and we need to stop for a minute or for whatever time is necessary, obviously we're going to accommodate that and just go ahead and speak up and let us know, and we will go ahead and stop the proceeding and the timekeeping. So let me ask for the 2 scoring panelists, Ms. Swihart and Mr. Landy, do either of you have any concerns that you may be biased in judging either team presenting here this afternoon?
No.
I do not.
Okay, and
I'm also a scoring judge. Sorry, Judge. I don't know if we're intended to have 3 here, but I don't know anyone here either. So.
I apologize. I did not realize that you were
problem.
serving as a scoring judge. And welcome, Mr. Chan. Can I ask you to pronounce your name, please?
Sure, it's Chandrasekhar.
Chandrasekhar. Does anybody, first of all, welcome, Mr. Chandrasekhar, as one of our scoring panelists. I apologize for not introducing you at the outset. So with that in mind, do any of the participants in the mock trial recognize any of the scoring panelists such that they feel like there might be bias by one of them? Not hearing or seeing any objection, the objection will be deemed waived since it's not been raised as a preliminary matter. So I need to remind the teams that and coaches that any disputes arising out of this competition must be reported in accordance with the competition rules. I need to remind the teams regarding their compliance with the timekeeping requirements and that going over the time allotted to each team for each task will be considered in scoring individual performances. So let me just confirm we have no coach or nobody who is not supposed to be here. I have not seen anybody join us. Let me start by asking each one of the participating team members, starting with the prosecution, to please introduce each one of the team members, including attorneys and witnesses.
Yes, Your Honor. Your Honor, members of the jury, opposing counsel, good afternoon. My name is Anna Debler, and today I will be providing the direct examination of Detective Jordan Markowitz, the cross-examination of Taylor Perkins, and providing the opening statement.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Kaylee Langen, and I will be providing the direct examination of Alex Cifuentes and the cross-examination of Avery Becker.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Anjali Mishra, and I will be providing the direct examination of Kyle Cusack, the cross-examination of Blake Van Owen, and I will be providing the closing arguments for the prosecution. At this time, we ask that our witnesses be allowed to introduce themselves.
Yes, please.
Good afternoon, Your Honor, members of the jury. My name is Hannah Moskowitz, and I am Jordan Markowitz.
Good afternoon, Your Honor, and members of the jury. My name is Raina Hilden, and I am Kyle Cusack.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Maggie Holland, and I am Alex Cifuentes.
Okay, great. Good afternoon. And why don't we ask now the members of the defense to please introduce themselves, both counsel and witnesses.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Braden Kerr, and today I will be performing the opening for the defense, as well as conducting the cross-examination of Kyle Cusack and the direct examination of Taylor Perkins.
Good afternoon, Your Honor, your members of the jury and opposing counsel. My name is Magdalena Bratic, and today I'll be conducting the direct examination of Blake Van Owen and the cross-examination of Alex Cifuentes.
Good afternoon, Your Honor, opposing counsel and members of the jury. My name is Charlotte Combe, and today I will be conducting the direct examination of Avery Becker, the cross-examination of Jordan Markowitz, as well as presenting closing arguments on behalf of the defense. At this time, we ask that our witnesses be allowed to introduce themselves.
Yes, please.
Good afternoon, Your Honor, members of the jury. My name is Jordan Ryan, and today I am Blake Van Owen.
Good afternoon, Your Honor, members of the jury. My name is Ella Walters, and today I am Taylor Perkins.
Good afternoon, Your Honor, members of the jury. My name is Olivia Longi, and today I am Avery Becker.
Great. Good afternoon to the members of the defense team, attorneys, and witnesses. So we just have a couple of last logistical items that we need to cover. First, when you're not making argument or participating in the witness, I ask that we keep the mute on the microphone. They've also suggested that it may make sense, as some of you are doing, to keep your video muted. And the reason is that it helps with the bandwidth. The video helps with the bandwidth, and the microphone being muted helps us deal with any background noise. Last but not least, I need to swear in each member of the who's participating here today. Normally, if we were in the courtroom, I would ask all of you to stand up, please. But I'm going to ask, starting with team members, to please raise your right hands. Do you promise that the presentation that you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? Yeah. And thank you. If there are any gallery members, I'm not sure if we have the YouTube set up yet, but anybody who's observing, including teachers and attorney coaches, family members and friends, if you could please raise your right hand. Do you promise to represent yourselves and present yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? And then scoring panelists, if you could please raise your right hand. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition? Okay. Looks like I have seen head nods and yeses from everybody. So it looks like we are just about set to begin. Let me just, this came up or was raised in the previous trial, and I think it makes sense to address here. If there are any issues with the technical end of things, such as there is a lag or delay that causes somebody from being able to effectively make their argument, we'll deal with that on a case-by-case basis. If it takes more than 10 or so seconds to resolve the issue, parties can ask the court to adjust the time so that somebody's not penalized because of lag or delay in the Zoom connection. I think the last thing I need to do is make sure that we are in fact live with the YouTube connection. So let me just message the folks at First Jefferson, First JD, and make sure that we are live with that. Sorry for the awkward silence. I just sent them a message, and hopefully we will hear back in just a few moments.
It's very real world experience, Judge. Sometimes we sit in courtrooms and we have awkward silences while people wait to do things. So it's good for the students to learn about this now.
Doesn't make it any less awkward, though.
I know.
And in case anybody's wondering why we need to wait to start, in addition to making sure the YouTube is started, one of the things you saw us do is we need to make sure that there's no issues or questions of bias between the judges and the team members. And so they ask us to wait so that we can make sure that there are no issues in any of the other courtrooms, even if there are no problems here. If another courtroom needs to make a switch, we're one of the courtrooms that can accommodate that. So just to fill the awkward silence with awkward information. So. So it looks like other courtrooms are getting started from looking at the YouTube channel, and it looks like we are broadcasting. So with that in mind, I'm going to go ahead and get started so that I can respect all the participants' time, all the young adults who are participating in this. So with that in mind, is the prosecution ready to begin with their opening statements?
Yes, Your Honor. Just briefly, the prosecution has a few preliminary matters.
Okay, yes, please go ahead.
Your Honor, the prosecution would ask that any time left over from the prosecution's closing argument may be reserved for a rebuttal.
Okay, and that's typically something that the court allows and is consistent with the rules of the proceeding. The only thing I ask, as you're aware, is that your team is responsible for keeping track of your time. And so to the extent you intend to reserve rebuttal time, then you'll need to keep track of how much time you're using in your closing statement.
Yes, Your Honor. The prosecution would also ask that all of the witnesses, except the defendant, would be constructively sequestered.
Okay. And typically that's something that would happen in a trial. Obviously, it's not something we can do here today, but in a case such as this, the witnesses would typically be sequestered and asked to leave the courtroom. We won't do that here today, but that is typically something that would be granted.
Yes, Your Honor.
The defense objects to that.
Okay, and what would be the ground?
Yes, Your Honor. According to Rule 4.3.1, sequestration is not allowed.
Right, and I think what Ms. Dobler is asking just for constructive sequestration, not that they actually be asked to leave, but if this were a real trial, that the witnesses be excluded. So the witnesses will obviously not be asked to leave the courtroom, but if this were a real trial, that would be granted sequestration.
Yes, Your Honor. Your Honor, the prosecution would also ask that both teams would have permission for trial technicians to display exhibits on the screen for purposes of entering them into evidence, or if they've already been entered into evidence, they would still be displayed for expedience sake.
Okay, and the defense's position on that?
We're fine with that, Your Honor.
Okay, so each side will be permitted to display and use the share feature on the Zoom courtroom. You can do so. No need to ask the court for permission, but feel free to do that if you would like. And any objections to specific documents or exhibits will be addressed at the time.
Yes, Your Honor. Your Honor, as exhibits are initially displayed on the screen, the prosecution would ask that it be recognized that this is just to display the exhibit to the witness and opposing counsel, not to the jury until those exhibits have been published.
Okay, any objection by the defense?
None, Your Honor.
Okay, that will be so ordered.
And last, Your Honor, the prosecution would ask that exhibits, once they have been entered, would be constructively published to the jury, but they will just remain on the screen.
Okay, any objection from the defense?
No, Your Honor.
Okay, so that will be so ordered as well.
Yes, Your Honor. And the prosecution would just ask that all these courtesies are extended to opposing counsel.
Okay, all courtesies extended one way will be extended to both sides in this matter.
Yes, Your Honor.
Any other preliminary matters from the people?
No, Your Honor.
Okay, any preliminary matters from the defense?
Yes, Your Honor, just a few. We firstly ask, in accordance with Tournament Rule 7.4, that both attorneys and witnesses be allowed to annotate exhibits after they have been admitted with Zoom annotation features.
Any objection from the people?
No objection, Your Honor.
That will be so permitted.
And Your Honor, just a preference, when an objection is sustained, would you like us to strike to move the testimony or consider it stricken?
Typically, the way it's handled is if the objection is made, ideally, if the objection is made before the witness answers, then the witness would not be permitted to answer if the objection is sustained. But my practice would be to strike the testimony afterwards. So I will address that. If I don't, please feel free to cue me in, and I will address that on the record.
Yes, Your Honor. The defense has no further preliminary matters and is ready to proceed.
Okay, thank you. Prosecution, whenever you're ready with your opening statement.
Yes, Your Honor. May it please the court. Your Honor, members of the jury, my name is Anna Debler, and today, along with my co-counsel, Anjali Mishra and Kaylee Langan, today I represent the people of the state of Colorado to bring forth the charges of murder in the first degree and burglary in the second degree against the defendant, Avery Becker, and to prove beyond a reasonable doubt that the defendant is guilty in this case. Members of the jury, this is a case of revenge gone wrong. For the past couple of years, the head coach of the Colorado High School mock trial team, Mackenzie Brackman, a litigator and the mock trial coach, volunteered his time with students. However, you will learn from the evidence provided today that he had a contentious relationship with one student in particular. Avery Becker, a senior on the team, and the defendant in today's case, was very skilled in mock trial and very passionate about mock trial. The defendant argued frequently with Coach Brackman about the coach's coaching style. The defendant arrived at practices and trials unprepared, and this made Coach Brackman angry. Because of his behavior, the coach even demoted the defendant to the B team, angering the defendant. You will learn from testimony today that this relationship took a turn for the worst when the defendant vandalized Coach Brackman's car after a heated argument at the regional mock trial competition. The coach then kicked the defendant off of the team. You'll hear today that the defendant then pleaded with their teammates, including Alex Cifuentes, for help to get back on the mock trial team. With no success, the evidence will show that the defendant sought revenge on the coach by intending to break into the coach's house. However, the evidence will show that this revenge went wrong. On Friday, March 6th, 2020, Coach Brackman was found dead, just inside the doorway of his own home. The police concluded that the defendant, Avery Becker, killed the coach. Today, the prosecution will call 3 witnesses to the stand who will provide testimony and meet the burden of proof in this case. The prosecution's first expert witness, homicide detective Jordan Markowitz, will take the stand. You will hear that Detective Markowitz has firsthand knowledge of the crime scene. You'll learn how the detective obtained forensic evidence, ring videos, cell tower records, and phone records, all of which tied the defendant to Coach Brackman's house at the time of the murder. Then the prosecution's second expert witness, investigator Kyle Cusack, will take the stand. You will learn that the investigator also has firsthand knowledge of the crime scene and will be able to confirm Markowitz's findings. This will be through methodically collected details that describe a struggle as the defendant entered the mock trial coach's home unarmed and was surprised that the coach was home, then stabbing the coach. Third, Ms. Alex Cifuentes will take the stand. You will hear that Cifuentes, a Colorado high school senior, was a member of the mock trial team, observed the tension between the defendant and the coach, and she will most importantly provide screenshots of a conversation with the defendant. This evidence will show that the defendant had intent to trash the coach's house. However, this revenge of burglary and vandalism went wrong and instead ended with the death of Coach Brackman. And jury members, be wary of the defense's witnesses. Listen closely to their testimony and look out for any bias they may include. The evidence provided today will detail that none of the defense's witnesses investigated the scene of the crime firsthand, and none of the defense's witnesses can provide a solid alibi for the defendant on the date March 6th, 2020, at the time of the murder. At the end of today's trial, my co-counsel, Anjali Mishra, will take the stand to give the prosecution's closing argument. She will remind you of the important details of the trial that will prove the defendant's intent and meet the prosecution's burden of proof. She will point to this being a case of the defendant's revenge gone wrong. We ask that you return a verdict of guilty. Thank you.
Sorry, I think I was muted. Whenever defense counsel is ready to begin their argument.
Yes, Your Honor. Ready?
Yes.
The easy conclusion. On the day of March 6, 2020, Detective Jordan Markowitz of the Denver Police Department arrived on the scene of a violent murder. Body laying on the ground, dead, was that of local attorney and high school mock trial coach Mackenzie Brackman. Murder was a puzzle. There were no fingerprints, no DNA, no eyewitnesses. The only thing they had was an inconclusive video of an assailant dressed head to toe, and they struggled to find any other conclusive evidence. So they settled on an easy conclusion, that the murderer must have been a student on Mr. Brackman's high school mock trial team. They decided on Avery Becker, a student at Colorado High School, who, as you heard from the prosecution, has a very interesting story about her. They decided she must have been out for revenge after getting kicked off her high school mock trial team. They dug up any possible, plausible shred of evidence they could find. And now, members of the jury, my client Avery Becker is fighting for her life. She's been charged with the crimes of burglary and murder in the first degree, which means she knowingly entered the residence of Mackenzie Brackman with the intent to commit a crime, and in the process of committing that crime, caused the death of Mr. Brackman. And it's going to be the job of the prosecution in today's case to prove to you beyond a reasonable doubt that this is what happened. However, as you will see, there are three things in today's case that will show you their easy conclusion simply isn't the right one. First, you will hear that their easy conclusion was impossible. You will hear Avery Becker's alibi. She will tell you where she was that day, but you won't have to take her word for it. Another witness, Taylor Perkins, will confirm every bit of her alibi. They'll both tell you they spent the entire day at the mall, never even thinking about Coach Brackman or mock trial. Second, you'll hear that the prosecution's easy conclusion in today's case was based on several critical investigative errors. You'll hear that the police never even bothered to verify whether screenshots of text messages Ms. Becker denies sending were legitimate or just hoaxes created by her jealous mock trial rival, Alex Cifuentes. You'll hear the police ignored the fact Avery Becker had lost her phone the day before the murder, meaning that you can't tell anything from the prosecution's cell phone data. But even more than that, you'll hear that the prosecution's own witnesses will testify to the fact that there was no physical evidence found in today's case. No fingerprints, no DNA, no eyewitnesses, nothing. But third and finally, you'll hear that the police ignored another conclusion. You'll hear from Professor Blake Van Owen that there was another suspect who could have committed the crime in today's case. You'll hear that this suspect matched the profile of the person the police were looking for. You'll hear that this person had a vendetta against the victim in today's case. And you'll hear that this person was unaccounted for at the date and time of the murder. Members of the jury, we still don't know where they are. So at the end of today's trial, my co-counsel, Charlotte Combe, is going to get up here and she is going to ask you for a verdict. And we hope you go with the verdict that ignores the prosecution's easy narrative about revenge gone wrong. And we hope you go with the right verdict, a verdict of not guilty. Thank you.
Great, thank you. the prosecution ready with their first witness?
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand.
Okay, Detective Markowitz, just as a reminder, you have been sworn in at the start of this proceeding, so whenever the people are ready to begin with their questioning.
Yes, Your Honor. Good afternoon, Detective. Can you please state your first and last name and spell your last for the record?
Of course, that's Detective Jordan Markowitz, last name spelled Markowitz.
And can you please tell the jury a little bit about your employment history?
Of course, I've been working for the Denver Police Department for the past 13 years, the past 7 as a detective there.
And do you have any special training in certain fields?
I do. I had the privilege of following one of my passions and doing a course at the American Academy of Law Enforcement in cell phone technology and forensic data recovery.
Can you please elaborate on that training?
Of course. It was a three-day training course in which we learned a variety of subjects, in which you had to pass a certification test in order to complete this.
And do you use this training in the field regularly?
I do. I've used it in over 50 cases that I've worked on.
Your Honor, at this time, I move to tender Detective Jordan Markowitz as an expert in the fields of forensic data recovery, criminal investigation, and cell phone technology.
Okay, any objection or request to voir dire this witness?
Yes, Your Honor, the defense specifically objects to tendering this detective in criminal investigation, as they have not provided any of experience, learning, or expertise pursuant to Rule 702 to be tendered as such.
Okay, Ms. Dobler?
Your Honor, if I may, under Rule 702, skill, experience, and training are all points to qualify an expert witness. The detective has said that she has 13 years under her belt, and so that is plenty of experience to be qualified in this field.
Any reply?
Yes, Your Honor, we don't know if that experience is having to do with criminal investigation whatsoever. The detective has only talked about her experience with cell phone technology and data recovery.
Ms. Dobler, can you just ask a couple of foundational questions regarding her investigation background?
Yes, Your Honor. Now, Detective, where did you work?
Again, I worked for the Denver Police Department for 13 years, the past 7 as a homicide detective, which does involve criminal investigation.
And what do you typically do on the job as a homicide detective?
As a homicide detective, I go to the scene of the crimes, help gather evidence, as well as identify the person and follow any leads as to who may have committed such a crime.
Your Honor, at this time, I would move to tender Jordan Markowitz as an expert witness in the 3 fields that I've mentioned.
Okay, and does the defense maintain the same objection?
No, Your Honor, enough foundation has been laid.
Okay, thank you. Detective Markowitz will be accepted as an expert in the field so identified by the prosecution whenever you're ready to resume your examination.
Yes, Your Honor. Now, Detective, what was your role in today's case?
I was called to the scene of the victim, Mackenzie Brackman, at approximately 2:20 p.m. on March 6, 2020.
And what were your conclusions about today's case?
Well, I concluded 3 things. The first, that the victim died in a struggle. The second being that the defendant, Avery Becker, had the intent to vandalize the home of Mackenzie Brackman. And the third, call detail records placed the defendant at the home of Mackenzie Brackman on March 6, 2020.
Now, let's talk about
is there an objection? Hold on 1 second. Was there an objection, Ms. Combs?
My apologies, Your Honor, I was not loud enough, but yes, I did make an objection.
Okay, and what is the ground?
Opinion on the ultimate issue, specifically the mindset or intention of the defendant to commit the crime.
Ms. Dobler?
Your Honor, the witness was just testifying to the intent of the defendant to break into the home, not to commit the murder, which would not be the ultimate issue.
Okay, Ms. Combs, any reply?
Yes, Your Honor, I just would like that to be clarified for the jury, that it was not for the intent of committing the crime, just going to the home.
Okay, so the objection will be overruled. Expert witness is permitted to testify as to the ultimate the ultimate conclusion as to what their opinion as to what happened, but the objection will be so noted. The jury will be so advised when we give a jury instruction at the end of this trial.
Yes, Your Honor. Now let's talk about that first conclusion, Detective. What did you do upon arriving at the scene?
Well, upon arriving at the scene, I entered through an open gate into the back door, which led into the kitchen of the home.
At this time, let the record reflect that the trial technician will be displaying exhibits 1 through 4. Now turning to exhibit 1, Detective. Are you familiar with all of these exhibits?
I am.
And what is exhibit 1?
Exhibit 1 specifically shows the view of the victim in relation to the front porch of his home.
And as we turn to exhibit 2, what is exhibit 2?
Exhibit 2 is a back angle of the victim showing his relation to the door.
Now turning to exhibit 3, what is exhibit 3, Detective?
Exhibit 3 is an image of the victim's stab wound in addition to his hand placements.
And now turning to exhibit 4, what is exhibit 4?
Exhibit 4 is a more zoomed out image to better show us the position of the upper body of the victim.
And how do you know what all of these exhibits are?
I was at the crime scene to observe this.
And are these all fair and accurate copies of what you observed?
Yes, they are.
Your Honor, at this time, I move to enter exhibits 1 through 4 into evidence.
Any objection?
No objection, Your Honor.
Okay, exhibits 1 through 4 will be admitted into evidence.
Yes, Your Honor. Now turning to exhibits 3 and 4, Detective, what was the importance of these two exhibits?
Well, these exhibits were very important to me as it tells a great story. That being that the victim died in a struggle. This is seen through the horizontal stab wound mark on the victim's left shoulder, in addition to his hand placement, which is laid out in a defensive position.
And from all this physical evidence, what did you believe to be the progression of events?
Well, I believed that the victim was involved in a struggle in which sadly and tragically led to his death.
And now turning back to exhibit 1, what else did you notice about the residence as you continued your investigation?
Well, if you look up in the upper right-hand corner of the image, you will see a Ring doorbell camera, which in his case recorded videos of the intruder on the day of the incident.
And did you use these Ring cameras in your investigation?
I did. I legally accessed several videos that helped me in this investigation.
And what did these videos show you?
The video showed the intruder coming in to the front door. Upon finding that it was locked, he maneuvered her way through the gate into the back door, where she engaged in a struggle with Mr. Brackman, thereby leaving through the front door.
And now let's talk about that second conclusion that you reached about Avery Becker's intent. Was there any evidence to point to Avery Becker as breaking into the home?
Yes, there was. Upon further investigation about the victim, Mackenzie Brackman, I found that he was a mock trial coach. With this information, I went to go and talk to some of his students, leading me to one Alex Cifuentes, who provided me with screenshots in which the defendant, Avery Becker, clearly stated her intent to vandalize the home of Mackenzie Brackman.
In your expert opinion, were those screenshots doctored in any way?
No, I do not believe they were doctored in any way.
Now, what did you do to investigate the defendant further?
Well, upon being refused an interview, I received a warrant for call detail records of Avery Becker's phone, or cell tower data.
And can you please explain to the jury in layman's terms what those records were?
Of course. I would love to continue on and on about this subject, however, I'll keep it brief. A call detail record, or CDR, shows any incoming or outgoing calls, the duration, the date, the time, and what tower it was connected to when this interaction was made.
Your Honor, let the record reflect that the trial technician is displaying exhibits 15 and 16 on the screen. Now, turning to exhibits 15 and 16, what are these two exhibits?
Both these exhibits show Becker's phone on the day of March 6, 2020, which towers they connected to, and 16 also has a dotted line showing the concluded path that Avery Becker took that day.
And how do you know what these records are?
I made them myself.
Do you often compile data and records in this way?
Yes, I do.
And are these fair and accurate copies of your records?
Yes, they are.
Your Honor, at this time, I move to enter exhibits 15 and 16 into evidence.
Any objection?
Yes, Your Honor, I have 3 different objections.
Okay.
First, best evidence pursuant to Rule 1002. Secondly, possibility of misleading the jury pursuant to Rule 403. And lastly, specifically with Exhibit 15, hearsay pursuant to Rule 801.
Okay. Ms. Doppler, any response?
I'll respond to the hearsay objection first. This isn't being used for the truth of the matter asserted, rather that a record was being made and used to collect data in this case. And then intent to mislead the jury, I believe, was the second objection. Clearly, since there are 2 separate documents, both one is explaining or is just a plain document and the second has marks on it, they're easily comparable and one is not being used to mislead. And then the third objection, was it your third objection?
I believe it was a best evidence.
Best evidence. Again, both pieces of a map are provided. So the first is showing the map and the second has the detective's markings on it. So there's an easily comparable record of the 2.
Okay. Any reply?
Yes, Your Honor. First, I think it would be best for me to clarify the grounds of my objections. With pursuant to best evidence, both of these diagrams are based off of call detail records that Detective Markowitz obtained from the defendant's cell service provider. Those call detail records of the initial connections her phone made to these towers would be the original, and these are simply a diagram of those, and thus we would need the originals pursuant to Rule 1002. Under Rule 403, in regards to misleading the jury, I'm specifically talking about the red range of each cell tower. Now, there's no demarcation on either of these exhibits, exactly how far these red towers and ranges go. And if I may make an offer of proof, Professor Von Owens is going to talk about the ranges of these towers being exactly 6 miles later on. So this has the possibility of misleading the jury to the exact range of these towers. And lastly, with my hearsay objection, I'm specifically objecting to the marking of Rock Creek Parkway on Exhibit 16 as an out-of-court statement being used for the truth of the matter. Opposing counsel can choose to constructively get rid of that marking before entering it, but that marking is hearsay.
Okay, and so based upon the arguments of counsel, I guess what I would say is with regards to misleading the jury under the 401, 403 analysis, I don't think that there's a danger that the probative value will be so substantially outweighed by the prejudicial nature of the testimony or the evidence. So the court does not find that to be a problem here. With regards to the best evidence rule, the court would actually find that these documents are summaries of the underlying phone records, and the defense will have an opportunity to cross-examine this witness, the detective, regarding any issues that may lie with the underlying documents that form the basis for the summary exhibit. With regards to the hearsay, I think that had Detective Markowitz made that line here in the court as a demonstration of her review of the evidence, that that would have been admissible based upon the stipulations and agreements made at the start of the trial. So the court will ask that the detective clarify when going through the documents, but otherwise the objection's overruled, and both exhibits 15 and 16 will be admitted into evidence.
Yes, Your Honor.
Yes, Your Honor. And if I would have had the opportunity, I would have pointed to Rule 103 that this is the next best evidence and is therefore admissible because the authenticity is not being challenged. Now, moving on, Detective. Let's talk about your third conclusion, that Becker's records pin him to the scene of the crime, or her, excuse me. Now, using exhibits 15 and 16, keeping in mind that we're not referencing the line that you made, can you please tell the jury what the call detail records tell about Avery's phone activity?
Of course. These call detail records led me to a progression of events by looking at the time in which the phone connected to each of the towers. Using this information, I deduced that from 12:45 to 12:50, Becker was home, then driving on Rock Creek Parkway towards Brackman's home, whereupon from 1:05 to 1:17 p.m., Becker was at Brackman's home, as shown by its connection to the cell tower 1197-1, the one closest to Brackman's home.
And in your expert opinion, what happened in today's case?
In my expert opinion, I believe that the defendant, Avery Becker, went to the home of Mackenzie Brackman, attempting to vandalize his home. Upon realizing he was home, she murdered him in cold blood, an act of revenge gone wrong.
Thank you. No further questions, Your Honor.
Okay, cross-examination.
Yes, Your Honor. One moment to pull up an exhibit I'll be using real quick. My apologies.
No worries.
Right. Good afternoon, Detective.
Good afternoon.
You didn't really mention this on direct examination, but you interviewed Alex Cifuentes, right?
I did interview Alex Cifuentes.
She told you about some text messages she had gotten, right?
And provided me screenshots.
Right. So she told you about those text messages and you wanted to interview her.
Yes, she did.
Your Honor, permission to screen share what has been previously marked as Exhibit 14.
Yes, please.
All right, Detective, these are the screenshots that Ms. Cifuentes sent you, correct?
That is correct.
And these are an accurate reflection of those screenshots?
Yes, they are.
Your Honor, at this point in time, the defense moves to enter Exhibit 14 into evidence.
Any objection?
No objections, Your Honor.
Exhibit 14 will be admitted into evidence.
All right, Detective, I want to ask you some questions about this exhibit.
Of course.
All right, so to begin, at the interview, you asked to see Ms. Cifuentes' phone, right?
Yes, I did.
Just to see those text messages on the phone, to clarify.
That is correct.
She didn't bring her phone with her to the interview, did she?
No, unfortunately, she did not.
And you thought that was odd?
Well, yes, but I lose my phone myself too, so in hindsight, it wasn't that odd.
So, Detective, that's a yes to my question?
Yes, it was odd at the time.
In fact, it might have been one of the only times you'd encountered a teenager without their cell phone on them, right?
Well, yes, but again, in hindsight, I lose my phone all the time and forget it, so...
Detective, I wasn't asking you about your opinion in hindsight. I'm asking, it might have been one of the only times you'd seen a teenager without their phone on them.
That is correct.
So you did not see any of the text messages in Exhibit 14 during that initial interview?
No, not the originals.
In fact, you never got to see Ms. Cifuentes' phone.
No, but at that point I had gotten the call detail records and the phone wasn't the most important thing on my mind. It was finding the defendant who had murdered Mackenzie Brackman.
Detective, I wasn't asking about the other evidence you used in today's case. I was asking if you ever got to see Ms. Cifuentes' phone, and you didn't, right?
No, unfortunately, I did not.
Detective, you have training in the Celebrite system, right? You mentioned that on direct.
I do.
Just to clarify, this is software used to download information off of cell phones.
Yes, it is. I learned it in my cell phone technology and forensic data recovery class at the American Academy of Law Enforcement.
Right, right. And you've downloaded the contents of hundreds of phones at this point, haven't you?
Yes, that is correct.
In fact, in this case, you downloaded information off of Mr. Brackman's phone, right?
I did. I used it to access the Ring videos.
And if you had obtained Ms. Cifuentes' phone, you would have been able to download the information off of it.
That is correct, but again, as you mentioned, I unfortunately did not have the opportunity to receive her phone.
So that's a yes to my question, Detective?
Yes.
So you chose to simply trust the screenshots she sent you.
I had no reason to believe they were altered, so yes, I did trust them.
Detective, I wasn't asking why you decided to trust those screenshots, but you did, right?
Yes, I did.
Your Honor, this question has been asked and answered. Though the witness added onto her answer, this question has been answered.
Any response, Ms. Combe?
Your Honor, I was just clarifying. I'm fine if that testimony is stricken from the record. I can move on.
Okay, so the court won't ask for the testimony to be stricken, just ask that we move on from this question. Thank you.
Yes, Your Honor.
All right, Detective, I now want to talk about Avery Becker's cell phone. All right?
Of course.
You don't know who was in possession of her cell phone the day of the murder, March 6th of 2020, do you?
No, but I do believe it was Avery Becker.
Respectfully, Detective, I'm not asking what you believe. I'm asking what you know.
Objection, Your Honor. This question has been answered. She clearly said no and then elaborated, but the witness clearly did answer this question.
Any response, Ms. Cohn?
Yes, Your Honor. I would prefer if the witness would give me a clear yes or no without elaborating. She can do that in redirect.
Ms. Dobler, any reply?
Your Honor, the witness did give a clear yes or no in this instance. She did elaborate, but she sometimes answers need more than a simple yes or no.
Okay, so what I'm going to say is typically in this situation, I advise witnesses to please answer the questions that are being asked of them. So I'm going to overrule the objection and ask the witness to answer the question that's posed, and the prosecution will have an opportunity to redirect if they so desire.
Yes, Your Honor.
All right. Detective, on March 6th of 2020, all of the calls and messages to Ms. Becker's phone were from Taylor Perkins' phone, right?
That is correct.
The calls were not answered.
No, they were not.
The texts were not responded to.
No, they were not.
Detective, Ms. Becker's lawyers told you that she lost her phone on March 5th, didn't they?
That is what they told me, yes.
Just to clarify, this is a day before the murder.
That is correct.
They told you that she was at the mall all day with Taylor Perkins.
That is also what they said.
Detective, you never checked the call detail records of Ms. Perkins' phone, did you?
No, I did not.
All right. I want to talk about the CDRs you mentioned in direct or call detail records, if that's all right with you.
Of course.
So, just to clarify, a cell phone connects with a tower that gives it the strongest connection, right?
Most often, that is the nearest tower.
Right. So most of the time, that is the nearest tower, just to clarify.
Yes.
All right. So if the nearest tower is busy, though, a cell phone connects with a tower that is further away. Am I right?
Well, sometimes certain phones only have the connection to go about 20 miles, which can be harder on them, so they do end up going to the nearest phone, especially with the iPhones being updated and slowing down every time Apple, has a new update feature or produces a new phone. It slows it down and therefore more often connects to the nearest tower.
Detective, I'm afraid you're getting a little bit ahead of me. I was simply asking if the nearest tower is busy, a cell phone will connect to one that is further away, right?
Yes, that is true.
And just to make this extra clear for the jury, sometimes then phones do not connect to the nearest tower.
Yes, but again, most of the time it does connect to the nearest tower.
So just to make it clear, that's the yes to my question.
Yes, it is.
All right, Detective, I want to take your attention to Exhibit 15 now. Your Honor, permission to screen share what has been previously entered as Exhibit 15?
Yes, please.
All right. Detective, can you see that all right?
Yes, but am I allowed to pull it up on my own just so I can better see it?
I'm going to be annotating this for your reference, so it might be easier if you
Okay.
Look on here. All right. So, Detective, I want to take your attention to this red circle, the middle cell tower that I'm circling in red right now, all right?
Mm-hmm.
So if Miss Becker's phone was right here on Rock Creek Parkway, like you said, and this cell tower wasn't busy, her phone would connect to it, right?
That is correct.
However, if if this cell tower was busy, Miss Becker's phone would connect to a cell tower that is further away, right?
Well, that is correct, but I don't think there'd be many people at the mall on a Friday afternoon doing school hours and work hours. So it seems unlikely, however, it is possible.
Detective, just to clarify, Rock Creek Parkway is a road, right?
Yes, it is.
People drive on?
Yes.
Get busy during rush hour?
Well, they shouldn't be on their phone during rush
This
hour.
question is calling for speculation. This witness does not have the expertise to testify as to the busyness of the road at a certain hour. It's not her field of expertise.
Ms. Combs?
Yes, Your Honor. Seeing as Detective Markowitz was the one to make this diagram, do the research with the call detail records, and where everything was located, it would make sense that she would have some background knowledge of to the busyness of Rock Creek Parkway.
Ms. Doppler, any reply?
Again, this does not go to her, the fields that she has been entered as an expert. She's simply making the records, not investigating the roads that are included in the records.
Okay, so what I'm going to do is I'm going to overrule the objection. Detective Markowitz can testify based upon her reasonable perceptions if she knows what the road is like.
Yes, Your Honor.
So, Detective, if that middle cell tower is busy, Ms. Becker's cell phone might connect to this bottom cell tower.
Yes, although I believe it unlikely for that day and that time.
Detective, I wasn't asking whether it was unlikely, but this is a definite thing. If this cell tower is busy, it's going to connect to another cell tower, and it might have been this one.
That is correct.
Her cell phone might have connected to this tower.
That is also correct.
Right, Detective? I want to shift gears now and talk about the range of these towers, if that's all right with you.
Of course.
I want to take your attention to this bottommost cell tower right here. I'm circling it now. Do you see that?
I do.
Just to clarify, Mr. Brackman's home is right here where I'm putting the green check mark, correct?
That is correct.
And Ms. Becker's phone could have been all the way over here and still connected to this bottommost cell tower.
That is a possibility.
Her phone could have been over here and still connected to this cell tower.
That is also a possibility.
So these call detail records can't pinpoint the exact location of a cell phone.
No, they cannot.
Thank you. No further questions.
Okay, any redirect?
Oh, Your Honor, could I possibly take a screenshot of this exhibit for use in closing?
Any objection by the people?
No, Your Honor.
Okay, please go ahead.
Thank you, Your Honor.
Thank you. Ms. Doppler, any redirect?
Yes, Your Honor, briefly.
Okay.
Detective, just touching on what was talked about on the cross-examination, do you believe there's a possibility that the phone could be at the mall while also being connected to the antenna by Brackman's home?
I do not believe that. Again, it was a Friday afternoon in the middle of a work and school day. In addition, opposing counsel mentioned that people on the road would be using it while they were driving. First, that is illegal, and second, I should hope that nobody would do that. Given that the cell tower on that day and time would likely not be busy, I do not believe that her phone could be at the mall while simultaneously being connected to the antenna by Brackman's home.
Thank you. No further questions, Your Honor.
Great. Any recross limited to the scope of redirect?
No, Your Honor.
Great. Thank you, Detective, for your time this afternoon. The people ready with their next witness?
Yes, Your Honor. The prosecution calls Kyle Cusack to the stand.
Okay, great. Just want to remind the witness that you have already been sworn in at the start of this proceeding. So whenever you are ready to begin your direct examination, Ms. Mishra.
Good afternoon, Ms. Cusack. Can you please state your name and spell your last for the record?
Your Honor, I think the witness is muted.
Oh, thank you.
My apologies. My name is Kyle Cusack, K-U-Z-A-K.
Now, can you please tell the court a little bit about your professional background and what you do for a living?
Yes, of course. I am a crime scene reconstructionist, and I have spent 19 years in my field.
Now, can you just explain to the jury what exactly is crime scene reconstruction?
Of course. So crime scene reconstruction is the process of identifying the steps which took place during a crime, mainly looking through the pieces of evidence we see in the aftermath and using those to find out what really happened.
Now, where do you work right now in your employment?
For the past 3 years, I have been a civilian employee of the city of Denver.
And what exactly have you investigated over your career working for the city of Denver?
I've investigated all sorts of crimes, everything from homicides such as this one to armed robberies, burglaries, fatal accidents, really quite a variety.
And what kind of processes do you use in these types of investigations?
Well, I mainly look at my work in 5 steps, those being recognition and documentation, evidence collection, evaluating that evidence, hypothesizing and testing, and then finally issuing my peer-reviewed report.
Now, is this type of report and investigation method common in your field?
Yes, of course. Among crime scene reconstructionists, the Bevel-Gardner method is quite well known, as well as my personal thought process very closely following the scientific method.
And are these methods peer-reviewed and staples in your line of work?
Yes, of course. All work that we publish must be peer-reviewed.
Your Honor, at this time, the prosecution moves to enter Ms. Kyle Cusack as an expert in crime scene reconstruction.
Any objection or request to voir dire this witness?
No objection, Your Honor.
Okay, the court will accept the tender of this witness as an expert in crime scene reconstruction. Whenever you're ready to resume.
Now, Ms. Cusack, how are you involved in this case today?
I did personally investigate the crime scene on March 6th, 2020, and observed evidence myself, as well as having obviously issued my final reconstruction report on the crime.
Now, moving on this reconstruction report, is this how you keep track of everything during your process?
Yes. Well, on my way to issuing my final report, I make evidence and witness tracking sheets, as well as a flowchart of events, which I all include in my final report and finalize before issuing it.
Now, allow me to direct you to Exhibit 17, which the trial technician will be sharing. Do you recognize this exhibit?
Yes.
What is it?
This is my witness tracking sheet, evidence tracking sheet, and flowchart.
And how do you recognize this exhibit?
I made these myself.
Is this a part of your regular methodology in investigating such cases?
Yes, of course.
And is this commonly used in your field by other experts?
Oh, of course. I mean, assuming every case a reconstructionist works on will go to trial is essential, and quite frankly, I wouldn't trust anybody who didn't thoroughly memorialize the evidence that they came across.
Your Honor, at this, excuse me, sorry. And is this a true and accurate copy of your work?
Yes, it is.
Your Honor, at this time, the prosecution moves to enter Exhibit 17 into evidence.
Any objection?
Yes, Your Honor. The defense objects hearsay to pretty much every part of this document.
Okay, any response from the people?
Your Honor, as this is an expert witness and this is her testimony, this goes to her expertise, as well as I've already laid the foundation to establish that under Rule 702, this is a record of regularly conducted business activity, as this is what Ms. Cusack does for her entire work, and it is peer-reviewed and a staple in her field.
Your Honor, may I respond?
Yes, please.
So according to Rule 803-7, there are a few things that something needs to be qualified as an exception from hearsay due to being a regularly conducted activity. That the evidence is admitted to prove that a matter did not occur or exist, record was regularly kept for that kind, and the opponent does not show a possible source of that information or other circumstances that indicate a lack of trustworthiness. Now, this exhibit they have failed to lay the foundation that this exhibit meets all 4 of these qualifications to be qualified under Rule 803-7.
Your Honor, if I may respond.
Just briefly.
It is clearly stated that under Rule 803-6 for records of regularly conducted activity, that this record was made near at the time the information was transmitted, which Ms. Cusack has established. She did this as she went through her investigation. This was part of a regularly conducted activity for her organization, the police department. This was a regular practice of hers, as she does this for every single case she investigates. She is the custodian of this document. As she has stated, she made this document, and the source of information and the circumstances of preparation do not indicate a lack of trustworthiness, as Ms. Cusack has been entered as an expert in this court today.
Oh, Your Honor, I apologize. I was looking at the wrong rule. I was looking at Rule 8037, absence of a regularly conducted activity. But for 8036, the prosecution has not laid the foundation that 8036C was satisfied, that making the record was a regularly conducted practice of that activity, and 8036D, that all of these conditions are shown by the testimony of a custodian or another qualified witness. They have simply just not provided enough foundation to show this.
Okay, and so upon reviewing the record and reviewing the testimony, the court's going to find that it does meet the hearsay exception found within 8036. In particular, I believe that Ms. Cusack testified that this was a regular practice of her activities as an accident reconstruction, and she did show that all of these conditions were met under the rule, and so the objection is going to be overruled and Exhibit 17 will be admitted into evidence.
Yes, Your Honor. Now, Ms. Cusack, referencing this chart that you have made, can you please explain to the court what happened during this break-in at its root?
Yes, of course. So looking at the third page, the flow chart, we can see that there were really 4 key groups of events, color-coded, of course. And they essentially, that was the perpetrator traveling to the victim's residence and attempting to break in, the victim noticing that a person was trying to enter his home, the 2 entering an altercation, and the victim eventually being stabbed and tragically bleeding out.
Now, let's break that down a little bit more for the court. What happened as the home was entered?
Yes, well, we can see from the ring security footage that the perpetrator first attempted to enter through the front door, and after finding that that door was locked, attempted to enter through the back door.
And what happened after that?
Well, the victim had either been notified by his ring security system or simply heard somebody attempting to enter his home, and he had then armed himself with a knife.
Now, what happened after the victim armed himself with a knife from his home?
Well,
Speculate. This is calling for speculation.
Any response, Ms. Mishra?
Yes, Your Honor. This witness has been entered as an expert and is clearly breaking down the crime scene reconstruction that they formulated for this case. They are not speculating. They are simply using evidence in the most logical way to form their conclusion.
Mr. Kerr?
Yes, Your Honor. I believe this witness has been entered as an expert in crime scene reconstruction rather than in what happened that day. I believe that this question specifically is calling for the witness to assert definitively what happened rather than what does the evidence show them or what does the conclusion lead them to, which is speculation.
Okay, so I would agree with the objection to the extent that the witness is testifying as to what she believed did. She can testify as to what she believes happened based upon her analysis of the evidence, but the question was framed up as what did happen, and that would be speculation. So the objection is sustained, but the question may be re-asked.
Yes, Your Honor, I'll simply re-ask. Ms. Cusack, based on the evidence that you analyzed and in your expert opinion, what occurred after the victim was alerted to the perpetrator entering their home?
Well, from what we observed at the crime scene, we could clearly see that a fight had occurred. There were fairly significant pieces of evidence there. There were scuff marks on the floor, a broken plate, and obviously the victim's body eventually.
Now, allow me to direct you to Exhibits 9 and 18, which the trial technician will be screen sharing. Do you recognize these exhibits?
Yes.
And what are these exhibits?
Exhibit 9 shows the broken plate in Mr. Brackman's kitchen, and Exhibit 18 shows the scuff marks near the back door.
And how do you recognize these exhibits?
I saw these things myself at the crime scene, as well as having reviewed these photos in my later reconstruction work.
And are these fair and accurate representations of what you saw at the crime scene and what you worked with during your investigation?
Yes.
Your Honor, at this time, the prosecution moves to enter Exhibits 9 and 18 into evidence.
Any objection?
No objection, Your Honor.
Exhibits 9 and 18 will be moved into evidence.
Now, Ms. Cusack, can you please explain to the jury why these pieces of evidence were important in your analyzation?
Well, seeing the evidence that supports a fight having ensued, it does become very important to understanding what led up to Mr. Brackman's death. Obviously, nobody would keep broken pieces of ceramics on their kitchen floor, as well as the fact that the scuff marks are seen to be very dark, suggesting very forceful movements.
Now, could these scuff marks been made during a regular day-to-day time for the victim?
It is incredibly unlikely. When people are simply walking around their house, they do not make motions forceful enough to create those scuff marks.
Now, let's move on and talk a little bit about the murder weapon specifically. Where do you believe, based on the evidence, this knife came from?
Mr. Brackman's own kitchen.
Now, allow me to direct you to Exhibits 5, 6, 7, and 8, which the trial technician will be screen sharing. Do you recognize these exhibits?
Yes.
What are these exhibits?
Exhibit 5 shows the knife as it was found at the crime scene. Exhibit 6 shows a photograph of the knife in the evidence processing lab. And Exhibit 7 shows the knife drawer found open in Mr. Brackman's home.
And what is Exhibit 8?
Exhibit 8 shows the knife block in Mr. Brackman's kitchen.
Thank you. Now, how do you know what these exhibits are?
I observed all of these things when I visited the crime scene, and Exhibit 6 at the crime processing lab, obviously, and as well as having referenced these pictures.
And how do you know are these pictures fair and accurate representations of what you saw?
Yes.
Your Honor, at this time, the prosecution moves to enter Exhibits 5, 6, 7, and 8 into evidence.
Any objection?
Your Honor, may I have the trial proponent doing this scroll up so I can see the first few pictures again?
Please.
The defense does not have an objection at this time.
Okay, Exhibits 5, 6, 7, and 8 will be admitted into evidence.
Yes, Your Honor. Now, can you please explain, using these pieces of evidence and your analysis that you performed, can you please just explain to the jury your analysis on the knives?
Yes, of course. Well, we can fairly obviously conclude that the knife found covered in blood next to the victim's body was the one used to murder him. But the fact that we see in the knife block only a single knife missing, as well as in Exhibit 7, the sheer number of knives the victim had in his home, we can very fairly conclude that he armed himself with a knife.
Now, referencing Exhibit 4, which has already been entered into evidence and will be screen shared by the trial technician, I believe it'll just take a moment. Can you explain to the jury what important analysis you gathered from this piece of evidence?
Yes, well, seeing that the knife wound is horizontal also greatly played into my scientific theory about...
Objection, Your Honor. This is speculation.
Any response?
Your Honor, I believe I simply asked for the analysis and the important information that Ms. Cusack was able to gather for this, and she is simply giving her expert analysis on one of the most important pieces of evidence in the case.
Mr. Kerr, any reply?
Yes, Your Honor. I believe this witness has been qualified as an expert in crime scene reconstruction rather than any kind of injury or wound analysis. And this is calling for an opinion outside of their expertise.
Based on the question that's been asked, I'm not sure that it's necessarily outside of the expertise of this opinion. So the objection is overruled and new testimony will be allowed. Whenever you're ready to resume the answer.
Yes, Your Honor. Ms. Cusack, would you like me to repeat the question for you?
No, I think I'm okay. Thank you. So we obviously see that the wound here is horizontal, and in my own report and analysis, I determined that the victim was ultimately stabbed in a sort of bear hug. So the two were wrestling over control of the knife, facing one another, and the perpetrator was able to hold the knife horizontally and swing into the victim's body.
Now, what is the significance of this knife wound being horizontal?
Well, it's very clear that the only way that the perpetrator could have created such a wound would have, or the most likely way, I should say, is by using the force of his bicep to get enough momentum to swing into the victim's body, even getting partially through the scapula. I'm aware that Blake Van Owen proposed a sort of psycho stabbing motion, but that report very obviously showed a vertical knife, while this wound is horizontal.
Now, I refer you to Exhibit 19, which the trial technician will be putting on the screen through screen sharing. Do you recognize the exhibit in front of you?
Yes.
What is this exhibit?
This is the autopsy report on Mackenzie Brackman.
And how do you recognize what this exhibit is?
I used the autopsy as a reference in my reconstruction.
And are autopsy reports like this common in murder crimes?
Yes, of course. I mean, when anybody dies, an autopsy report is completed, and as reconstructionists, we rely on them when fatal injuries do occur.
And as a report created by the police department, is this piece of evidence a public record?
Yes, this came from the City of Denver Office of the Medical Examiner, who does work with the police often.
And is this a fair and accurate copy of the autopsy report that you worked with throughout?
Yes.
Your Honor, at this time, I move to enter Exhibit 19 into evidence.
Any objection?
Yes, we object to hearsay.
Okay. Any response?
Your Honor, as I have established, this piece of evidence is both a record of regularly conducted activity and a public record, so it is a hearsay exception.
Okay. Any reply?
Your Honor, this is not they've not laid the foundation to show that this is a public record, and mainly because of 8038B is that the opponent does not show the source of the information nor other circumstances indicate a lack of trustworthiness, which we will do on cross-examination. And for the records of irregularly conducted activity, they have not shown that all of these were satisfy the records of 8038D, that this was created by a certified custodian of this record.
Your Honor,
Okay.
if I may respond?
Okay, just briefly, yes.
Your Honor, I believe Ms. Cusack openly just stated right now that this was created in partnership between the medical office and the City of Denver Police Department and is a public record, so it is an exception to hearsay.
Okay. And Mr. Kerr, any last reply?
I still stand by my objection.
Okay, and so considering the record and the testimony that's been presented to the court is going to find that it is subject to the hearsay exception under Rule 803, 8, and Exhibit 19 will be admitted into evidence subject to cross-examination.
Yes, Your Honor. Now, Ms. Cusack, given the evidence that you analyzed, in your expert opinion, did the perpetrator initially intend to kill Mr. Brackman upon entering his home?
Well, we saw through the ring security footage that the perpetrator entered unarmed. And we also know that the knife came from Mr. Brackman's own home and a fight had ensued, suggesting that the perpetrator was surprised that Mr. Brackman was still home and had not been intending to commit murder, rather simply break into the home.
And given your analysis and in your expert opinion, who is the perpetrator in this crime?
Given all of our investigation on this case, it is Avery Becker.
Your Honor, no further questions at this time.
Okay, cross-examination.
Yes, Your Honor. So, Ms. Becker, let's start a little bit by talking about your conclusion.
Ms. Kuzak.
Oh, my apologies. Ms. Kuzak. Let's start by talking a little bit about your conclusion in today's case. Now, you believe that the person who went to the Brackman residence and didn't intend to kill Brackman.
Yes.
But it is possible that the person who went there did intend to kill Brackman, correct?
Well, we do see that the perpetrator enters unarmed, and generally when people intend to harm another person physically, they enter with the weapon they intend to use.
Miss Kuzak, I'm not asking about that. I'm asking whether it's possible the person who went there intended to kill Mr. Brackman.
It is possible, but unlikely.
So that's a yes?
Yes.
So let's talk about this a little bit. You mentioned on direct a set of scuff marks found near the back door, correct?
Yes.
Now, you don't know when these scuff marks were made, do you?
We do not.
These could have been made a week before this incident occurred.
It is possible.
Could have been made a month before this incident occurred.
Yes.
And heck, they could have even been made a year before this incident occurred.
Yes.
I guess let's next talk about the murder weapon. Now, the knife in this case was of the brand Chicago Cutlery. Is that correct?
Yes, that is correct.
And the knife from Mr. Brackman's knife sets were from a J.A. Hinkle's brand, correct?
Yes, that was the knife block, but we also saw he had a drawer full of knives.
But the knife from Mr. Brackman's knife sets were different from the murder weapon, correct?
The brands did differ, yes, but the sizes aligned.
Well, you saw those exhibits just like I did, and I thought that the Chicago Cutlery one had a silver handle. Is that correct?
That is correct.
Well, the ones from Mr. Brackman's knife block appear to have a black handle. Is that correct?
They are different brands, and yes, they do have different colored handles.
So let's move on a little bit to talk about the perpetrator in today's case. So you reviewed video evidence of a Ring video security system. Is that correct?
Yes.
And would you recognize these videos if I showed them to you?
I would recognize those.
Your Honor, let the record reflect that I am going to show this witness a record of what has been marked as Exhibit 12.
Okay.
Now, Ms. Kuzak, you reviewed this exhibit, correct?
I did.
And this is a fair and accurate representation of that exhibit.
It is.
Your Honor, at this time, the defense moves to qualify Exhibit 12 into evidence.
Any objection?
Sorry, Your Honor, I could not unmute. No objection to this piece of evidence.
Okay, Exhibit 12 will be admitted into evidence.
So, Ms. Kuzak, let's just take a minute and watch this. Now, you saw that the person entering the house was fully covered, correct?
Yes, that is true.
They had a mask on.
They did.
Full overcoat.
Yes.
And you can't really tell anything about this, can you?
Well, we can see their figure as well as, and that is, and how they compare in height to the doorway, things like that.
But you can't tell specifically what this person's height is, can you?
No, not exactly.
You can't tell what this person's eye color is.
No, they were wearing a mask.
You can't tell what this person's hair color is.
No.
Can't tell about this person's racial background.
No.
Can't even tell this person's gender, can you?
No, we cannot.
So let's finally move on to talking a little bit about the physical evidence in today's case. Now, you reviewed all of the exhibits in today's case.
Yes, I did.
You read over all the witness statements.
I did, yes.
You even visited the crime scene.
Yes, I did, the day of the murder.
So you would agree with me if I said that there was no physical evidence tying Avery Becker to the scene of the crime?
In what way do you mean that? I'm sorry, I'm not quite sure I understand your question.
Well, you saw in that video that the perpetrator was touching the back door, correct?
Yes, that is true, but they were wearing gloves, so ultimately the perpetrator did not leave any fingerprints.
Getting a little bit ahead of me, but exactly, the perpetrator didn't leave any fingerprints.
That is correct, but fingerprints were not the only evidence we rely on in crime scene reconstruction.
Well, you didn't find any DNA evidence, did you?
We did not. The only genetic evidence we found was from the victim.
So you didn't find any DNA evidence in this case, did you?
We did not, other than from the victim.
And you didn't even find any kind of eyewitness who places Avery Becker near the scene of the crime, did you?
We have cell phone tower records placing Avery Becker at the scene of the crime, as Detective Markowitz confirmed.
Ms. Cusack, I'm not asking about cell phone records. I'm asking about an eyewitness, and there were none.
No, the only people in the home were Mackenzie Brackman and the perpetrator.
So there was no evidence of Avery Becker present at the crime scene, was there?
We do have cell phone tower evidence placing Avery Becker at the crime scene.
But no DNA evidence?
No genetic evidence or fingerprints.
So no DNA, no fingerprints, no eyewitnesses.
No, as I said earlier, the only two in the home were the perpetrator and victim.
Thank you. No further questions.
Okay, any redirect limited to the scope of cross?
No, Your Honor.
Okay, thank you for your testimony here this afternoon, Ms. Cusack. And are the people ready with their next witness?
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand.
Okay, Ms. Cifuentes, just as a reminder, you were placed under oath at the start of this proceeding, so whenever the people are ready.
Good afternoon, Ms. Cifuentes. Can you please state your name and spell your last name for the record?
My name is Alex Cifuentes, spelled Sifuentes.
And how do you know the victim in this case, Mackenzie Brockman?
Mr. Brackman was our mock trial coach.
And how do you know the defendant in this case, Avery Becker?
Avery and I were super close. We were besties on mock trial team, coached by Mr. Brackman.
And what was your opinion of the defendant?
Although we were friends, I did not appreciate and I was not fond of the way that Avery treated our teammates or Mr. Brackman.
And why were you not appreciative of the way that the defendant treated your teammates and Mr. Brockman?
Well, Avery constantly played the victim and refused to work hard. And even though Mr. Brackman pushed Avery to be the best that she could, she just wouldn't have any of it.
Can you please describe briefly the first incident in which the defendant and Mr. Brockman butted heads?
Well, after Avery came to practice late for the umpteenth time, Mr. Brackman demoted Avery to the B team. And after that, Avery manipulated Taylor Perkins into quitting for her.
Objection, speculation.
Any response?
Your Honor, the witness's testimony is simply based on her observations and do not call for speculation.
Any reply?
Your Honor, I believe Ms. Cifuentes just testified that Avery Becker manipulated Taylor Perkins into leaving the mock trial team. She cannot testify to the actions or the thoughts of somebody else, and if she cannot testify to the actions and thoughts of someone else, and she has not laid any foundation as to how she might know that.
Okay, so the objection is sustained with leave for the people to re-ask the question and lay foundation in support of that.
Yes, Your Honor. Ms. Cifuentes, can you please describe how you perceived the incident in which the defendant was demoted from the A team to the B team?
Well, Avery was super angry about this and did everything that they could to get back on the team.
And can you please briefly describe the second incident in which the defendant and Mr. Brockman butted heads?
Well, at the very next practice, Mr. Brockman tried to explain to Avery about the difference between showmanship and being a good lawyer. And Avery was so angry that she stormed off with a permanent marker and wrote "Worst Attorney Award" in all caps on the hood of Mr. Brockman's car.
More prejudicial than probative, improper character evidence, and relevance.
Any response?
Yes, Your Honor. This witness is simply testifying to their observation, and seeing as this goes to the character of the defendant, it is very relevant in this case.
Any reply?
Yes, Your Honor. The prosecution is trying to admit Ms. Becker's act of vandalism as a prior bad act to show that she killed Mr. Brockman. If they're not entering this for this probative value, which they cannot under Rule 404, then it's not relevant to today's case.
I guess what I would say in this instance is that the court's going to find that it is relevant just to show the relationship between the parties, and that it is the probative value is not substantially outweighed by the prejudicial nature of the testimony, so the objection is overruled.
Yes, Your Honor.
Now moving on, Ms. Cifuentes, I would like to direct your attention to Exhibit 14, which has already been entered into evidence. Now, reading along with me from one of the text messages sent from Avery Becker. Ms. Becker, or the defendant, said, "Well, if he's still upset about this car, then he's going to be really upset when he sees what I do to his house." Ms. Cifuentes then responded, "What are you going to do to his house?" Ms. Becker then responded, "I'm going to wait until he's at work, then break in and trash it." Did I read that correctly?
Yes, you did.
No further questions, Your Honor.
Thank you. Cross-examination?
Yes, Your Honor, but before I start, may I have a time check, please?
.427.
Just one moment. Good afternoon, Ms. Cifuentes. I'm just going to ask you a few more clarifying questions. Now, Avery Becker was kicked off the mock trial team, correct?
Yes, that is correct.
You say that she sent you texts after she was kicked off.
Yes.
You say that she had texted you with the intent to vandalize Mr. Brockman's house.
Yes, I believe that is Exhibit 14.
After the murder of your coach, you got a call, correct?
Yes.
It was from a police detective.
Yes, it was.
You told the police detective about the texts.
I did, and they asked for screenshots.
Exactly. They asked for screenshots. However, you offered to bring in your phone.
Well, I did because I had my phone. I bring it with me most places. So I offered to, but they said it was enough, and that's all that there was to it.
And just to be clear, Ms. Cifuentes, you didn't bring your phone to the interview.
No, I did not.
Currently, you have no idea where your phone is.
I still have I have my phone with me. The one,
Is it your testimony in court today that you have your phone with you, Ms. Cifuentes?
well, the old phone with the bad battery. I mean, I know that's in a junkyard somewhere. My current phone I have.
So just to be clear, you don't know where the old phone is, the one with the text that's shown as Exhibit 14.
No, I don't know where that one is.
Now, you and Avery Becker worked on the same mock trial team.
Yes, that's correct. We were teammates and we always pushed each other to be better.
Exactly. You pushed each other to be better, but you thought Avery's behavior left the team in a state of anxiety.
Well, I will agree that Avery's work ethic didn't match that of the other teammates. So yeah, in terms of mock trial, it was a bit of a challenge working with her.
You thought that she had a lackadaisical attitude.
Yeah, that's true. That's what I gathered from all of my years being close with her and being friends.
You don't think Avery won any awards because of any real talent?
No, I believe Avery had talent, just a lack of work ethic.
Ms. Fuentes, is it your statement in court today that you thought Avery won awards because of talent?
I just believe that Avery won the awards. Mock trial wasn't always fair, and the scoring panels could be flipped sometimes.
But you worked hard on all of your mock trial material, Ms. Fuentes.
I did. I take a lot of pride in how much time I put into mock trial.
Exactly. You began your drafts as soon as Mr. Brackman assigned them.
Yes, I'm very passionate about my craft.
You worked so hard that it irked you whenever Avery made up things on the fly.
I mean, it did. It irked everybody.
When Avery was kicked off the team, you thought that was for the best.
Well, it put the team at ease. And yes, for that reason, I would say it relaxed us a little bit.
With Avery gone, you were excited for the larger role you were going to get.
Well, perhaps with Avery, not in mock trial, but not Avery in jail. That's not what I want.
But just to be clear, once Avery was gone, you were excited for the role you were going to get.
Again, without Avery on mock trial, not in jail. I want that.
Objection, unresponsive.
I'm not actually sure I really heard much of the response. So any response to the objection, Ms. Langen?
Your Honor, I believe that the witness was answering the question. If it is not the way in which counsel would like her to answer, this is up to her to ask a follow-up question. My witness is answering the way in which she believes is appropriate.
Any reply?
Yes, Your Honor. Ms. Fuentes did not answer my question with a clear yes or no answer.
Okay, so what I'm going to say is I'm going to overrule the objection, but allow you to re-ask the question if you would like.
Just to be clear, with Avery gone, you were excited for the larger role you were going to get.
With Avery not in mock trial, correct, I would have had a bigger role. That's it.
Thank you. No further questions.
Okay, any redirect?
Yes, Your Honor. Ms. Fuentes, would you have stood to gain had Avery been kicked off of the mock trial within the current season?
No, we would have had to forfeit our position at state. It was not the best situation for us. It was not we wouldn't have been better without her.
That's time, Your Honor.
Okay, thank you.
And I have no further questions.
Thank you. And I would normally ask for any cross. I'm aware that you're out of time as well, so I am not intentionally excluding you here. Do the people have any other witnesses?
No, Your Honor, the people rest.
Okay, thank you. Is the defense ready with their first witness?
Yes, Your Honor. The defense calls Blake Van Owen to the stand.
Okay, great. Ms. Van Owen, just a reminder that you are under oath, as you were put under oath at the start of this proceeding. So whenever a defense is ready with their first questions.
Good afternoon. Could you please introduce yourself to the jury?
Good afternoon. My name is Blake Van Owen.
What do you do for a living, Ms. Van Owen?
I'm a private investigator as well as a professor down at CU Denver.
What education do you have?
I obtained a master's degree in criminal justice from Ashford University.
Do you have any experience in police investigation?
I do. I actually started out my career over at the Aurora Police Department.
How many cases have you consulted on?
As a consultant, over 100. It's been quite a while now.
What does a typical case consultation look like for you?
Well, people hire me as a consultant to look at the investigations done by a police department. So I look at their procedures, their methods of evidence gathering, their crime scene reconstructions, and I evaluate their use of evidence and reliance on evidence.
Have you testified in court before?
I have, actually, all across the Western United States.
In what areas do you testify as an expert witness?
I've testified in crime scene reconstruction 8 times, cell tower analysis 5 times, as well as general police investigation 12 times.
Did you do anything in preparation for today's case?
Of course. I reviewed the exhibits put together by Detective Markowitz. I actually reviewed the crime scene reconstruction from Kyle Cusack, and I conducted my own partial investigation.
Your Honor, at this time, the defense would like to tender Ms. Van Owen as an expert in police procedure, crime scene reconstruction, and cell tower data analysis.
Any objection or request for voir dire?
No objections, Your Honor.
Okay, so the court will so admit this witness to testify as an expert in the field so described.
Ms. Van Owen, could you tell the jury what you concluded about the police's conduct during the case of Avery Becker?
I concluded that the police ran an incomplete and rather haphazard investigation, which involved their over-reliance on cell tower data, as well as their failure to investigate some key pieces of evidence, and their failure to investigate all possible suspects.
Let's take those apart one by one. First, could you tell the jury why you concluded that the police relied on the cell tower data too much?
Yes, the police almost used the cell tower data as a GPS, and cell tower data is not a GPS. It works by a phone itself connects to the tower that gives it the best signal. Sometimes it's the closest, sometimes it's the furthest away. And the police assumed that the phone's location was the same as Avery Becker's location.
How often do phones connect to the closest tower?
Well, it depends. In urban area, for example, cell phone towers often have a radius of about 6 to 7 miles, and it's decently common for a cell phone tower to connect to a tower that's further away because towers get very busy in these populated areas.
What can the cell phone records tell us about Avery Becker's location on the day Mackenzie Brackman was murdered?
If we look at the call detail records, we can see that from Tower 1191, antennas 2 and 3, which cover the mall and the fry shack, show Taylor Perkins sent calls and texts at the same times that Avery Becker received calls and texts, which goes along with the fact that the two of them were looking for Becker's phone.
You've told us about the cell phone records. Now I'd like to move on to the evidence collection in today's case. You mentioned that the police failed to investigate certain pieces of evidence properly. Could you elaborate more on that?
Of course. Specifically, the police never investigated Alex Cifuentes' phone in person.
How were they able to investigate the texts on Alex Cifuentes' phone?
To try and investigate those texts, they relied upon screenshots, which can be very easily falsified or doctored.
Even if they had Alex Cifuentes' phone in front of them, would they have been able to authenticate the text messages?
Yes, absolutely. The police have a specific technology called Celebrite, which allows them to download the contents of a phone and look through and see if things are real or not to authenticate things.
Just to be clear, did the police do that in today's case?
No.
Finally, I'd like to discuss why you concluded that there were alternate suspects in this investigation. Throughout your investigation, why did you conclude there were alternate suspects?
Well, I came across someone who had a very strong motive for committing these crimes, whose name is Blair Rollins.
What possible motive could Blair Rollins have had?
Well, Blair Rollins' father, Jonathan Rollins, had actually been a former client of Mackenzie Brackman's. Jonathan Rollins had been put on trial for murder. It had been Mackenzie Brackman's job to defend him in court.
Was Blair Rollins present for his father's trial?
Yes, Blair Rollins testified actually on Jonathan Rollins' behalf.
Did you end up investigating the trial?
Of course I did. I actually relied on several audio recordings and able to further my investigation.
Are you familiar with Exhibit 22?
I am. That's one of those audio recordings.
Is it an authentic representation of the trial?
It is.
Is it a fair and accurate representation of Jonathan Rollins' trial?
Absolutely.
Your Honor, at this time, the defense would like to enter Exhibit 22 into evidence.
Sorry, any objection?
Yes, Your Honor. The opposing counsel has not offered this piece of evidence to the court or to the prosecution, which is required by mock trial rules in order to submit evidence.
Any response to that?
Yes, Your Honor. First of all, I'd like to clarify which rule opposing counsel is referring to. And secondly, I believe opposing counsel managed to get the packet of evidence before today's trial, so they should be familiar with all of the exhibits included in today's case.
Okay, Ms. Mishra?
I believe if you refer to the Colorado High School mock trial rules and the rules for submitting a piece of evidence outlined in the very beginning of the rules, which opposing counsel should have had access to before this trial, it clearly states that the evidence should be shown or given at least to opposing counsel so that we can verify it before it is entered into evidence. It is simply the etiquette and the rules of Colorado High School mock trial.
Okay, last reply, Ms. Bratchik.
Yes, I believe opposing counsel does have access to all the exhibits in this case, so they should already have access to Exhibit 22 and be able to authenticate it.
Okay, so based upon my review of the exhibits listed in this case, Exhibit 22 is listed as one of the exhibits that are available to be used in this matter. And so with that in mind, there's no prejudice that has been described otherwise based upon any technical failure to provide a copy of the exhibit before the proceeding. So the objection is overruled.
Yes,
and Exhibit 22 will be admitted into evidence.
All right, Ms. Van Owen, I'm going to play this audio recording for you. And I want to tell me if you can hear it and what you hear. One moment while I pull it up.
I'll get you back, Brackman, if it's the last thing I do.
Ms. Van Owen, were you able to hear that?
I was.
Could you tell the jury what we just heard?
Well, that was Jonathan Rollins threatening revenge on Mackenzie Brackman.
Just to be clear, could Blair Rollins have heard his father's remarks?
Most certainly.
Throughout your investigation, did you make any other conclusions about any similarities between Blair Rollins and the killer?
I did. In the course of my investigation, I found out that Blair Rollins is the same size and build as Avery Becker.
Did you make any conclusions about the whereabouts of Blair Rollins on the day Mackenzie Brackman was killed?
I did. Blair Rollins was noticeably absent from school that day.
Miss Van Owen, did the police department investigate Blair Rollins at all?
They did not.
Did they investigate any other alternate suspects?
Not to my knowledge, no.
Finally, Miss Van Owen, what did you conclude about the police's conduct in today's case?
I concluded that the police made several major errors early on in their case that led the case going down the wrong path. They came to an easy conclusion, but it was the wrong one.
Thank you. No further questions.
Okay, great. Cross-examination.
Yes, Your Honor. Good afternoon, Ms. Rollins. Now, you used to work for the Aurora PD, correct?
At the start of my career, yes.
But you left and you now work as a private investigator.
That's correct.
Where you are paid much, much more.
I suppose so, but it's not about the money for me, let me assure you.
But you have charged over $7,000 for this current case today.
It's been a long time coming. Yes, that's pretty average actually in my line of work.
And you expect that you will be paid at least $1,000 more after your testimony here today.
Objection, Your Honor. Relevance?
Any response?
Your Honor, I am simply going into the background of this witness and what they are paid. This is completely in line for cross-examination question of a expert.
Any reply?
Yes, Your Honor. What Ms. Van Owen is being paid doesn't make the fact that Avery Becker could have killed Mr. Brackman any more or less likely. Therefore, it is not relevant to today's case.
Your Honor, if I may respond.
Okay.
I believe this goes simply towards the bias of this witness.
Okay. Any last reply, Ms. Pratchett?
Yes, Your Honor. Simply being paid for one's job does not add any bias to helping Ms. Avery Becker or going against Ms. Avery Becker in today's case.
Okay. Limited testimony regarding what the witness is paid and what they might be paid at the conclusion of the trial is relevant to the credibility and may go to motivation or bias by the witness. Therefore, the objection is overruled and the testimony may be admitted.
Yes, Your Honor.
Yes, Your Honor. Now, would you like me to repeat that question for you, Ms. Van Owen?
That would be nice, thank you.
So you expect that you will be paid at least $1,000 more after your testimony here today in court?
That would be correct.
Now, a large part of your testimony here today seems to be trying to refute the prosecution's arguments.
Well, that is what I was hired for, so I should hope so.
So let's address one of these claims. You claim that that Blair Rowlands is a possible suspect in this case.
Yes, the lack of investigation is particularly concerning.
Yes, you were unsatisfied with the police's investigation.
That's correct.
So you took it upon yourself to do the investigation and you found out their height and build.
I was able to discover that. That's correct.
And you investigated the court case in which Rowlands' father was prosecuted.
I did.
You even managed to find an audio clip of Blair Rowlands shouting out.
I believe it was Jonathan Rowlands, but
oh,
yes.
Excuse me, Jonathan Rowlands shouting out.
I did.
But despite all of that work, you were not able to actually track down Blair Rowlands.
No, in my investigation, I attempted to, but it appears that Blair Rowlands has actually fled from the state.
But as a private investigator, you were not able to find him.
That's correct.
And the court was not able to interview him or even subpoena him to testify today.
That would be correct, yes.
So we know very, very limited information about Blair Rowlands, and we're not able to verify any of the allegations you have put forth.
I certainly wouldn't say that. I certainly wouldn't say there is limited evidence. I think in comparison with this case, there is pretty good evidence.
But do you know where Blair Rowlands is?
No, not personally.
Were you able to find any evidence to pin Blair Rowlands to the crime scene on the day of the murder?
Oh, well, certainly the person from those Ring videos looked similar, but my concern was more the lack of
investigation. But you weren't able to find any evidence, such as cell phone records, that would have even pointed to Blair Rowlands being at the crime scene.
That wasn't my job, so no.
But you have investigated Blair Rowlands and found a lot of information about him, correct?
I found some, but the full extent of the investigative responsibility lies with Detective Markowitz.
But despite all of your investigation, you still did not find anything that could even point you towards Blair Rowlands being at the scene of the crime.
No, that's incorrect. As I said, the Ring videos provide very good evidence.
So you agree that the Ring video of the suspect is enough evidence to indicate a criminal or indicate a suspect?
No, I agree that the Ring videos could shed light onto possible suspects and that people who match the descriptions of that warrant further investigation.
So just as the Ring video was important to you and indicated that it could be Blair Rowlands, it also indicated for Detective Markowitz that the perpetrator was Avery Becker.
I'm not sure entirely how they came to that conclusion, but apparently so.
Now let's move a bit on to the actual events of the crime. You claim that Coach Brackman was sitting at his kitchen table when he was stabbed in the back.
That certainly seems the most likely scenario.
Okay, so let me walk through what that means for the court. That means that the intruder tried to enter the home through the front door, triggering the Ring security system, correct?
Yes, I believe that's what we've seen.
And after that failed attempt to break in, they then entered through the back door.
That's correct.
Again, triggering the Ring security system.
That's also correct.
They then went from the back door into the kitchen of the home.
Indeed.
In an unfamiliar house that they had likely never been in.
Yes.
And finally, they snuck up on the victim and stabbed him in the back.
I do certainly see that as a very plausible scenario, despite how you make it sound based on the evidence that I discovered. I believe that it was in fact a surprise attack.
So you're claiming here that during all of this commotion of the breaking and entering, Mr. Brackman simply stayed seated with his back to his kitchen door?
I do. There is no evidence whatsoever that Mr. Brackman was aware of an intruder at his home. The Ring video doorbell system does not necessarily send notifications, and Mr. Brackman doesn't necessarily pay attention to notifications.
But the perpetrator still attempted to enter the home through the front and back door and managed to get in, all while Mr. Brackman still keeping his back to the door and sitting down?
Counsel, I don't really think I can testify as to what exactly was going through Mr. Brackman's mind, but based on
he still remained seated, as you claimed.
Objection, Your Honor. Opposing counsel is badgering my witness and not letting her finish her testimony.
Any response?
Your Honor, I am simply limiting the witness's response, as I believe opposing counsel did on the prosecution's witnesses as well, so I'm not really sure in which way I am badgering the witness.
Ms. Bradshaw?
Your Honor, I believe opposing counsel is not letting my witness answer to the extent that opposing counsel's questions are asking for. I'm simply asking.
If you would like, I can simply limit her to speaking in yes or no answers only so that this cutting off will not ensue, Your Honor.
Okay, so what I guess I would say at this point is the questioning technique being used seems to be intended to prevent kind of extra explanations that are beyond the scope of the question, and so the objection is overruled.
And Your Honor, I request that in order to prevent any further objections, that the witness be asked to limit their answers to a simple yes or no.
Okay, so I guess what I would say with regards to that is to the extent that that I would ask the witness and all witnesses to answer the questions that they are asked. I can't put an order in telling the witness to answer yes or no, because I don't know if the questions are going to require yes or no answers. And so I'll overrule that objection, but also ask the witnesses to try to answer the questions that they're asked. And a reminder that opposing counsel will have the opportunity to ask you clarifying questions afterwards and redirect.
Yes, Your Honor. Now, would you like me to re-ask my question?
Yes, please.
So you are saying that during all of this commotion of the breaking and entering, Mr. Brackman simply stayed seated at his kitchen table with his back to the door.
That is definitely my understanding of it, yes.
Now, referring to Exhibit 20, which the trial technician will be screen sharing for the court, and scrolling to the second page, you state that the perpetrator held the knife in a way shown in the picture.
I believe that is certainly possible.
With the blade point first and with the knife point first and the blade vertical.
In that picture, certainly, yes.
But that is also what you claim happened in the actual crime.
I believe that knife was held in that manner, yes.
And that is, and that it was used in a normal stabbing motion, similar to the famous stabbing in the movie Psycho.
I believe it was something like that.
All the while the knife remaining vertical.
That was my recollection. The main thing to take away from my evidence is that it was not, in my professional opinion,
Ms. Van Owen, I'm not asking for further explanation. I'm just asking you to simply state whether or not it was your theory that the knife was being held in that manner. Now, you claim that this is also the most common way to hold such a knife.
Some knives are built to be held weird ways, so yes.
And you claim that holding the knife in this specific way in a vertical stabbing motion would result in the victim's injuries.
I believe so, yes.
Now, the trial technician will be screen sharing Exhibit 4, and I direct you to it. Now, this knife wound is clearly horizontal, correct?
I can see the tear in the shirt is horizontal. I'm not sure I have an excellent view of the actual wound as it penetrated the skin. I can only really see the shirt wound.
But as the knife would have had to go through the shirt in order to wound the victim, it is clearly, as anyone can see, horizontal, correct?
The cut through the shirt is, yes.
And this does not match the vertical knife positioning that you claim was used.
That was one of my suggested ideas. So in that case, it wouldn't. But
But
again,
that was your main theory, that the knife was held in that way. You even went as far as including a picture in your report.
I wouldn't clarify that as my main theory, counsel.
So are you saying that you had multiple confused theories in this case?
No, I'm saying that that wasn't the basis of my professional experience in consulting with this case. My professional...
Well, if it was not the basis, wasn't it certainly your conclusion, though?
It was one of the possible conclusions. But again, you're forgetting. My job is to evaluate the police, not to hold up this evidence in the light of court.
But you also claim that Miss Cusack's explanation of the struggle and crime was incorrect.
Absolutely.
And yet your analyzation of the knife's holding position from the perpetrator does not align with the actual wound.
Again, my theory still holds up based on the evidence. The knife may be a little bit amiss, maybe. I'm not sure that the wound actually was different as I couldn't see it.
So are you saying that you did not even analyze to figure out the orientation of the wound?
It wasn't necessary in my professional opinion. My professional
So
opinion...
in your professional opinion, it was not necessary to analyze the wound fully in a murder case?
No, it was my professional opinion that it was unnecessary, some of the more minor details. The big
minor details that would have helped you figure out how the knife was being held?
I believe that even if it was held horizontally, the same theory still holds in place, if that's what you're asking.
But in order for it to be held horizontally, the perpetrator would have had to hold their arm at an angle and not get the substantial force needed to penetrate inches into the victim.
I didn't go into the specifics on that in my witness statement, but I'd be happy to talk about them with you.
But wouldn't it make more sense if this injury was occurred from the back, in which they could get the proper range of motion and hinge the elbow to get the force needed?
I wouldn't agree.
But your analysis still does not match that, correct?
I'm sorry, could you clarify, please?
Your analysis of a vertical knife does not match up with the horizontal wound.
No, but there are several ways it could have happened. The fact
and according to the coroner's report, when the knife nicked the aorta, there was heavy internal bleeding within the victim.
That's correct. Aortas are pretty bloody.
Which means that the victim died very quickly.
Yes.
So what you're saying is the victim was sitting at the table, got stabbed, pulled the knife out, stood up and walked to his front door.
Well, I doubt it was walking. I see it plausible that maybe there was some stumbling after the stabbing.
But he still made it to his door, all while bleeding heavily.
Yes, that's correct.
No further questions, Your Honor.
Okay, thank you. Redirect.
Yes, Your Honor. Ms. Van Owen, does your salary today affect any of the conclusions you have been making?
Absolutely not, never.
Is it your burden to prove that Blair Rollins killed Mr. Brackman?
It is not. I'm just analyzing what the police said and how it was incorrect.
Is it your burden to prove anything in today's case?
Not at all.
Thank you. No further questions.
Recross limited to the scope of redirect.
No, Your Honor.
Okay, thank you for your testimony here, Ms. Van Allen. Is the defense ready with their next witness?
Yes, Your Honor. The defense calls Taylor Perkins to the stand.
All right, Ms. Perkins, just a reminder that you are placed under oath at the start of this proceeding. And whenever you are ready, Mr. Kerr.
So, Ms. Perkins, could you please introduce yourself to the jury?
Hi, my name is Taylor Perkins.
And what is it you do for a living, Ms. Perkins?
Well, I'm currently a freshman at CU. I'm a theater major.
So you're a freshman. Where did you go to school before this?
Colorado High School.
And do you know the defendant in today's case, Avery Becker?
I do. She's my best friend.
So, Ms. Perkins, do you know whether Avery Becker murdered Mackenzie Brackman?
Absolutely, I do. I was with her the entire day.
So, did she?
Absolutely not, no.
Now, let's back up a bit. What was your relationship with Avery Becker like?
Really good. I mean, we were best friends and we did a lot of really fun activities together. We did musical theater, mock trial, obviously school, and then we just hung out a bunch.
Could you explain to the jury what this mock trial activity is?
Of course. It's really similar to musical theater without the dancing and the singing. Well, there was that one time, but usually there's not singing.
And do you know the victim in today's case, Mackenzie Brackman?
I do, yeah.
Were you able to observe the relationship between Mackenzie Brackman and Miss Becker?
I was.
What was it like?
Tense is probably the best way to put it.
What happened?
Well, about a month before regionals, Avery came in unprepared, and she could always pull it off just amazingly because she was just that good, but I guess it was just something that really irked Mr. Brackman.
And what came of this?
Well, like I was saying, about a month before regionals, she came in unprepared again, and it was kind of obvious. I mean, she still was amazing, but I guess it was just the last straw.
Why was this the last straw?
I guess I thought he got annoyed with how unprepared she was and demoted her to B team.
So what did you decide to do?
Well, this sounds really bad, but I didn't really like mock trial. The whole reason I was on it was because I had friends and I didn't want to do it if I didn't have friends on it. And I had musical theater and a bunch of other stuff going on in my life, so I quit in solidarity.
Now, were you aware of what happened to Avery after you quit?
I was.
What happened?
Well, she got kicked off.
So after she got kicked off, did you still associate with her?
I mean, absolutely. She's my best friend.
And did you meet with her the day before the murder occurred, the 5th?
I did, yeah. She came over to my house. We had some food, played some games on our phones, and then we were hungry again, so we went to the Fry Shack.
What is the Fry Shack?
It's this really popular restaurant near Colorado High School. It's really cool because they have really good food.
Objection, Your Honor, relevance?
Any response?
I can move on, Your Honor.
Okay, and the objection will be sustained.
Yes, Your Honor.
So, Ms. Perkins, what happened at the Fry Shack?
Well, when we got there, we saw a bunch of mock trial people, and I guess Avery got a little bit upset and she went to the bathroom.
And when she went to the bathroom, did she leave anything behind?
Yeah, I think she left her phone.
Now, what happened after she came back from the bathroom?
Well, we were kind of done with the Fry Shack, so we just decided to go to the mall instead.
And did you ever see if Avery picked up her phone again?
I didn't. I guess I just assumed that she had.
So let's talk about the next day, the day of the murder. What happened on this day?
Well, Avery usually picks me up from school, or drops me off, I guess is a better way to do it, say it. And I was texting her and she wasn't responding.
And did you ever figure out why this was?
Yeah, she told me that she'd lost her phone.
So what did you two decide to do?
Well, we didn't have much going on in school. We took our lit quiz earlier in the week. Tech week was the next week, so we didn't have musical theater. So we decided to spend the day looking for it.
And did you ever find it?
No, I mean, I was texting it and calling it, and we just didn't find it.
So what did you spend your whole day doing?
Looking for her. We went to the mall and the fry shack.
So that whole day, was Avery with you?
Yeah, the entire day.
Did she ever leave your side?
No, not at all.
So did Avery Becker murder Mackenzie Brackman?
Absolutely not.
Thank you. No further questions.
Okay. Cross-examination.
Yes, Your Honor. Good afternoon, Ms. Perkins. We'll start by looking at your relationship with the mock trial coach, Mackenzie Brackman. Now, you thought Brackman was a mediocre coach, isn't that true?
I thought he could make some mediocre decisions for our team, I guess.
And he was a mediocre lawyer as well, yes?
I thought so, yeah.
And you thought Coach Brackman made bad choices for the team?
I thought he could, at times, yes.
And as you mentioned on direct, the defendant is your best friend.
She is.
And you knew the defendant and Coach Brackman had a feud, isn't that correct?
I did. I mean, I didn't really entertain it, though.
And now, prior to the regional tournament, the defendant was demoted to the mock trial B team, isn't that true?
She was.
Brackman demoted the defendant.
Yes.
But the defendant was reprimanded once more by Brackman, yes?
Yes.
The defendant wrote Worst Attorney Award on the coach's car, yes?
Yeah. Coach Brackman said some really horrible things to her, saying that she didn't deserve her awards, and I guess she just decided to play one of her pranks and wrote on her card. She told me she thought it was dry erase marker, but I guess it wasn't.
Now, because of this, the defendant was kicked off the team, yes?
Yeah, she was.
Now, Coach Brackman kicked the defendant off the team, yes?
Yes.
So you looked for her ways to help the defendant get back on the team.
Of course, I mean, she was my best friend.
But Coach Brackman didn't let your best friend back on the team.
He didn't, unfortunately.
Now, let's look at your relationship with the defendant. You initially stepped down from the mock trial A team for Avery, yes?
Of course. I mean, mock trial just wasn't fun without her, and she was way better than I was, and she could take the team to state.
Now, you even said on your direct that this was in solidarity with the defendant.
Of course.
And now on March 6th, you mentioned you were with Avery the entire day.
I was.
No one who was at the Fry Shack can vouch for your whereabouts for the entirety of March 6th, 2020.
Well, I'm not sure that that's true. I'm sure if you asked someone either at the Fry Shack or at the mall that they would have said that they've seen us, but I guess the prosecution
Now, that's not my question, Ms. Perkins. I asked for the entirety of the day.
I suppose not for the entirety of the day, but definitely for a solid portion of the day.
Now, no one who worked at the mall can vouch for your whereabouts for the entirety of March 6th, 2020.
Again, I suppose not for the entirety, but I'm sure if you asked other people, they would have said that they'd seen us.
Now, Ms. Perkins, were there other people that can vouch for your whereabouts for the entirety of March 6th up here on the stand today?
No, not for the entirety of the day.
Thank you.
Other than Avery Becker, of course.
No. That's right. And Avery Becker was your best friend.
She is.
And now, Ms. Perkins, no other individual was with you and Avery Becker for the entirety of March 6th, 2020. Isn't that correct?
Well, I mean, I guess if you don't count our musical theater, like music friends, I guess. Not like people, but like the songs.
So that's a yes. No person was with you too.
I suppose not, no.
Thank you. No further questions.
Okay, redirect, limited to the scope of cross.
Yes, Your Honor. So, Ms. Perkins, on the date of the 6th, you spent a bit of your day at the Fry Shack?
Yes, and the mall, looking for Avery's phone.
And were there other people there?
Yeah, the mall was packed.
And did you hear any testimony from today's case from either Detective Markowitz or Kyle Kuzak that they interviewed anyone from the mall?
No, not at all.
Did you hear them testify about interviewing anybody from the Fry Shack?
No.
Thank you. No further questions.
Great. Recross, limited to the scope of redirect.
No, Your Honor.
Great, thank you for your testimony here this afternoon. Is the defense ready with their next witness?
Yes, Your Honor. The defense calls Avery Becker to the stand.
Okay, good afternoon. Ms. Becker, just a reminder that you were placed under oath at the start of this proceeding. And so whenever defense is ready to begin with their questions.
Good afternoon. Please introduce yourself.
Good afternoon. My name is Avery Becker.
Now, Ms. Becker, you're here today because you've been charged with murdering Mackenzie Brackman. Did you kill Mr. Brackman?
No, I didn't.
We'll get back to him more in a moment. But Ms. Becker, what does your life look like now?
Well, you know, it's not the greatest, but I have a real hope for the future. I can't wait to go to college, continue my mock trial journey. You know, my ultimate goal is to be a mock trial coach. So I'm really excited for
relevance.
Response?
Yes, Your Honor, we're simply providing some context as to who the defendant of this trial is. We'll keep it succinct.
Any reply?
Your Honor, I stand by my objection. I do not believe the defendant's future goals have anything to do with the case today at hand.
Okay, and so typically this type of evidence would be admissible just to provide a little foundation for who the witness is. So with the representation that the testimony will be succinct, the objection is overruled.
So, Ms. Becker, just to clarify, would you like to finish the end of your answer to my question?
Oh, sure. All I was going to say is that being a mock trial coach is like my ultimate goal, and I'm really hopeful that I can fulfill it one day.
Ms. Becker, what is mock trial?
Mock trial is a really fun activity. It's an extracurricular that I participated in. It's like a play, but instead of putting on a musical or a play, we put on a court case where both the high school students play both lawyers and the witnesses.
Did you enjoy the activity?
Of course I did. It was probably my favorite out of all of the activities I did. It came naturally to me. It was just something I was really good at.
Who was your coach?
Coach Brackman, Mr. Mackenzie Brackman, was my coach for all 4 years of high school.
What was your relationship like with Mr. Brackman?
I'll be honest, it was not the greatest. We definitely had some tension and had our disagreements about how mock trials should go.
We'll talk more about that in a sec. But for now, I want to talk about the day of the murder, March 6th of 2020. Where were you?
I wasn't at school. I had made the decision that day to skip school with my bestie, Taylor Perkins, to go to the mall. We were actually looking for something there.
What were you looking for?
My phone. It had gone missing the night before when I was at the Fry Shack. I had it, I went home, I woke up the next morning, and it was gone.
Ms. Becker, were you ever able to find your phone?
Well, Taylor and I, we looked a lot. We looked all over. And Taylor called my phone several times, but we never found it.
All right, Ms. Becker, earlier you mentioned you were on Mr. Brackman's mock trial team all 4 years of high school. Were you successful in this program?
I'd say it's pretty successful. By the time I was a senior, I had made it to the A team, which is the top team. And I even won a couple of awards at a regional tournament. I was really proud of those.
What awards did you win?
Best Attorney Award and Best Closing Argument.
How did Mr. Brackman react after you won those awards?
We were at practice a couple days after the competition when he and I got into a small argument. It was about the awards.
What did he say?
Well, during that argument, Mr. Brackman told me that I didn't deserve the awards. He told me that I had only earned them because of my good looks and charm, that the judges at state would see right through me, which I thought was really odd for him to be saying as a coach to me, a student. And I didn't like it. So after that argument, I did something terrible.
Ms. Becker, what did you do?
Well, I was done talking to Mr. Brackman, so I stormed out. On my way out, I grabbed what I thought was a dry erase marker. I wrote on his Porsche, Worst Attorney Award. I totally thought that it would just come out and that would be that, but I found out later that the marker was permanent, and I felt horrible.
Did Mr. Brackman find out?
He did. He had followed me out into the parking lot and made the decision then and there to kick me off the mock trial team permanently, which I understood.
Did you try to apologize to Mr. Brackman?
Of course I did. You know, even though his words were wrong and they hurt, I knew that what I had done was just as awful, and I wanted him to know how sorry I was. So I went the very next day in person to apologize, but he didn't want to see me. His secretary would not let me in.
Were you able to apologize to him?
I ended up texting him. Since I couldn't apologize face to face, I figured that was the next best thing. So I texted him an apology, and I even offered to get a summer job just to repay his car.
Why did you want to apologize to Mr. Brackman so much?
I knew my actions were really, really wrong, and I shouldn't have done them, no matter how angry I was at his words. I wanted him to know that.
Ms. Becker, I now want to talk about some other people involved in today's case. Did you hear Alex Fuentes testify earlier today?
I did.
Now, Ms. Fuentes claims you sent her a text asking for help to get back on the mock trial team after you were kicked off. Did you ever write that?
No. If I was going to get back on the mock trial team, I wanted to earn Mr. Brackman's forgiveness first.
Ms. Fuentes also claims you sent her a text saying you were going to wreck Mr. Brackman's home. Did you ever write that?
Absolutely not. I don't even know where Mr. Brackman lives.
Ms. Becker, did you see the ring videos brought up earlier in today's trial?
Yes, I did.
Are you the person in the ring video?
I'm not. I get that that person and I have a similar height and build, but that's a pretty common body type. A lot of people can look like that.
Ms. Becker, were you at Mr. Brackman's home the day of the murder?
No, I was at the mall with Taylor.
Ms. Becker, did you want to hurt Mr. Brackman?
I didn't. In the days before his unfortunate death, I was still doing everything that I could to show him how sorry I was.
Thank you. No further questions at this time.
Okay, great. Cross-examination.
Yes, Your Honor. Now, Ms. Becker, you did not like Mr. Brackman.
Our
Is this
relationship
correct?
was, oh, my apologies. Our relationship was tense, that's for sure.
Mr. Brackman never gave you credit for anything that you did. Isn't this correct?
He liked for things to be planned out and prepared, and I didn't necessarily follow that structure.
You thought Mr. Brackman had a big ego.
I did think that, yes.
Brackman always criticized your work. Isn't that correct?
Well, he's our mock trial coach. That was his job. I didn't always take his criticisms well, though.
You argued with Mr. Brackman at almost every single practice.
Like I said, we had very different approaches to mock trial, and that caused tension.
Thank you. Now let's move back to the question that I just asked. You and Mr. Brackman argued at almost every single practice.
That's correct.
You told Mr. Brackman that he wouldn't know a good cross if it hit him over the head.
That was something I said.
Mr. Brockman demoted you from the A team to the B team.
He did. I guess he just didn't like how I functioned in mock trial.
According to you, the B team is full of losers.
I mean, they are the B team for a reason, and I was put on the A team for a reason.
Yes, thank you. Now, moving back to the question that I just asked. The B team is full of losers.
I did think that, yes.
Now, you were able to make it back onto the A team after your best friend, Taylor Perkins, stepped down from her position.
That's correct.
Then, this was 1 week before the regional mock trial tournament.
Yes, I believe so.
After winning the Best Attorney and Best Closer award at the regional mock trial tournament, Mr. Brockman told you that you did not deserve any of these awards.
He did. Like I said, we were at practice a couple days after the regional tournament when we got into an argument about the awards, and he said some really hurtful things.
Yes, and these hurtful things pushed you to the breaking point.
I wouldn't say the breaking point, but they did cause me to do some regrettable actions.
But they did push you to write across the hood of Mr. Brockman's car, Worst Attorney Award.
That was something that I did, and I thought it would just wipe off. Honestly, I totally thought it was dry erase marker. And when I found out it wasn't, I was so ashamed and embarrassed of myself and my actions.
Now, irrelevant of what you thought the marker was, the marker did end up being a permanent marker. Yes or no?
Unfortunately, it was.
After Mr. Brockman saw the vandalization of his car, he kicked you off the mock trial team permanently.
Yes, he did make that decision.
Then you went home and lied to your mother about the reason why you were kicked off the mock trial team.
I wouldn't say I lied. I just didn't tell her why. I told her that Brackman kicked me off with no good reason.
Yes, those were your words. You vowed to get back at Mr. Brockman if it was the last thing you did.
That was something I said, but I absolutely did not mean it.
Yes, this is something you said. Now, moving on to your best friend, Taylor Perkins. You were best buds with Taylor Perkins.
Yeah, Taylor and I are super close. I'm really proud she's pursuing her musical career.
And Miss Perkins is your alibi for the day of March 6th at the time of the murder of Mackenzie Brockman.
She is. We were at the mall all day.
No further questions, Your Honor.
Great, thank you. Any redirect?
Yes, Your Honor. Ms. Becker, on cross, you were asked about something you said to your mom the day you were kicked off the mock trial team. Could you clarify what you said and why you said that?
I had gone home just after being kicked off the team, and I told my mom that I would get back at Brackman if it was the last thing I did. That was something I said, I will admit that, but it was never something that I meant, and it was never something that I was going to follow up on.
All right. And Ms. Becker, the prosecution is saying that today is a case of revenge gone wrong. Did you want revenge?
Absolutely not. I was still doing everything that I could to show how sorry I was for my actions against Mr. Brackman in his final days.
Thank you. No further questions.
Okay, recross limited to the scope of redirect.
No, Your Honor.
Great, thank you for your testimony here this afternoon. Any further witnesses for the defense?
No, Your Honor, the defense rests at this time.
Great, okay, so that concludes the evidentiary portion of our trial here today. The parties will now each have an opportunity to present closing arguments. Because it's the prosecution's burden of proof, they have an opportunity to make a closing argument and then a rebuttal statement. If the prosecution wishes to reserve any time, they may do so, but they will be responsible for keeping track of their time and using that time within the 5-minute allocation. Are the people ready for their closing statement?
Yes, Your Honor.
Okay, whenever you're ready.
Excuse me. May it please the court, Your Honor, members of the jury, my name is Anjali Mishra, and today my co-counsel Anna Debler, Kaylee Langen, and I represent the people of the state of Colorado. Today we have brought forth the charge of murder in the first degree and burglary in the second degree against the defendant Avery Becker. The case today can be explained with a simple story of revenge gone wrong. Mr. Brackman was stabbed in the back in his own home by one of his students, Avery Becker. The prosecution today has the burden of proof, and members of the jury, we have met that burden. We have proven to you beyond a reasonable doubt that the defendant is guilty of murder in the first degree and burglary in the second degree. Now, in this case today, you first heard from the prosecution's witnesses. You heard from Detective Jordan Markowitz, who is experienced in cell phone forensics. She explained how CDR usually connects to the closest tower and how this is most likely what happened with the defendant's phone. These phone records and CDR in Exhibits 15 and 16 indicate that Miss Becker was at the scene of the crime at the time of the murder. You then heard from Kyle Cusack, a certified crime scene reconstruction investigator who broke down her extremely thorough methods. She analyzed a wide array of evidence, most notably the murder weapon. She told you how the horizontal orientation of the blade only makes sense with her theory of the struggle. She explained how the evidence indicates that Mr. Becker was murdered by Miss Brackman in an act of revenge during a burglary gone wrong. You finally heard from Alex Cifuentes, a student on the Colorado High School mock trial team, who explained to you how Miss Becker often slacked off and how her repeated failures resulted in her demotion from the team. She told you about the contentious relationship between the victim and the defendant. You next heard from the defense's witnesses in this case today, and at the beginning of this trial, my co-counsel Anna Debler told you that this is a case of revenge gone wrong, and she warned you to be careful when approaching the testimony of the defense because members of the jury, it is filled with bias and falsehoods. You first heard from Blake Van Owen, who left a job in public service working for the Aurora PD in order to become a highly paid private investigator. Her theory of the knife being held vertically makes no sense with the clear horizontal knife wound. She baselessly tried to attack the prosecution's case, but her accusations were not substantial enough to provide reasonable doubt. You then heard from Miss Taylor Perkins, the best friend of Avery Becker. She is the defendant's sole alibi today. Miss Perkins disliked mock trial and manipulated Coach Brackman by threatening to quit in order to get the defendant back on the A-team. Due to this relationship, members of the jury, Miss Perkins is clearly completely biased, and I ask that you disregard all of her testimony here today. You finally heard from Miss Becker herself. She told you how tense her relationship with Mr. Brackman was, how she in vengeance insulted Mr. Brackman and called him the worst attorney in the state, how she in vengeance vandalized his car, damaging thousands of dollars of property, and got kicked off of the mock trial team, how she in vengeance vowed to get back at Mr. Brackman if it was the last thing she did, how she in vengeance reached her breaking point. The murder of Mackenzie Brackman was a simple story of revenge gone wrong. Our duty today as the prosecution is to prove that the defendant is guilty of murder in the first degree and burglary in the second degree. And we as the prosecution have met this burden, members of the jury, and we have proven to you beyond a reasonable doubt. I ask that you find in favor of the prosecution and find the defendant, Avery Becker, guilty on all charges. Thank you.
Thank you. Closing remarks from the defense.
Yes, Your Honor. Before I begin, can you see and hear me all right?
I can, yes.
And just to clarify, would it be okay for me to screen share the screenshot I took of Exhibit 15 during my closing today?
Yes, please.
the easy conclusion. Miss Mishra just got up here and told you that today is a story of a case, revenge gone wrong. However, you just heard Miss Becker tell you that she didn't want revenge. She was apologizing to Mr. Brackman in the days leading up to his murder. The only thing that went wrong here is the prosecution's faulty investigation. You heard today they spent so much time trying to prove how Mr. Brackman died that they forgot to tell you who did it. Members of the jury, we're here today to figure out who did it. They forgot to tell you that because they chose the easy conclusion. And when you make the easy conclusion, you tend to miss a lot of key details along the way. You heard from both Avery Becker and her good friend Taylor Perkins today, who told you that she was nowhere near Mr. Brackman's home the day of the murder. The prosecution tried to bring in call detail records or CDRs to prove that Ms. Becker's phone was at Mr. Brackman's residence. However, as you heard from Detective Markowitz herself, these CDRs don't act as GPS. They can't exactly tell us where Ms. Becker's phone was the day of the murder. And even if they could, it wouldn't matter. Avery Becker lost her phone on March 5th, a whole day before the murder even took place. She was at the mall all day with Taylor Perkins looking for her phone. Professor Von Owens looked into Taylor Perkins' cell phone record and found that connections with her cell phone were made at a cell tower that covered the mall in Freistadt, consistent with her alibi. Detective Markowitz didn't bother to check the alibi of her primary suspect. Detective Markowitz chose the easy conclusion. The prosecution, time and again, also had a lot of failures in their investigation. For instance, Exhibit 14, a key and crucial piece of evidence that shows the supposed self-incriminating text messages from Avery Becker to Alex Cifuentes. Detective Markowitz did not use the extensive training she had in the Celebrite system to download these text messages off of Ms. Cifuentes' phone. Instead, she trusted screenshots Ms. Cifuentes sent her. Screenshots that could have easily been doctored messages that Ms. Becker denies ever even writing. Again, Detective Markowitz chose the easy conclusion. Finally, we heard from the defense today about someone named Blair Rollins, a key alternate suspect that went completely ignored by the prosecution. You see, Blair Rollins' father, Jonathan Rollins, was sentenced to life in prison. And his attorney was Mr. Brackman. We showed you Exhibit 22, where Jonathan Rollins screams, "I'll get you back, Brackman, if it's the last thing I do." Blair Rollins was in the courtroom when his father said those words. Blair Rollins wasn't at school the day of the murder. Blair Rollins is the same height and build as the murderer, and now Blair Rollins is nowhere to be found. The prosecution is actively choosing to convict Ms. Becker without exhausting all other alternate leads. They are actively choosing the easy conclusion. So, we have an ignored alibi, an investigation reliant on errors, and an ignored alternate suspect. What does that mean for you, members of the jury, in the decision you should be making at the end of today's trial? Well, the prosecution carries a burden of proof. They had to prove to you that on the 6th of March, 2020, Avery Becker unlawfully trespassed on Mr. Brackman's property and caused death while on property. They had to prove both of these things to you beyond a reasonable doubt. Members of the jury, beyond a reasonable doubt is the highest burden in our criminal justice system. So if you found it odd that Detective Markowitz failed to check the alibi of our primary suspect, that is reasonable doubt. If you questioned why Detective Markowitz chose to trust a piece of evidence that could have been tampered with, that's reasonable doubt. If you found it weird the prosecution failed to look into a key alternate suspect, members of the jury, that is reasonable doubt. The prosecution chose the easy conclusion today. We're asking you to choose the right one. Thank you.
Great, thank you. Ms. Mishra, I know that you, I wasn't sure if you had intended to make any rebuttal statement. You did have a small amount of time left over. Did you intend to make a rebuttal statement?
Yes, Your Honor, briefly.
Okay.
And can I ask for the exact time that I have left?
It's like 45 seconds.
Thank you. This case today can be broken down into a simple rule of three. 3 clear examples of the defendant's vengeance. 2 experts who both concluded that the perpetrator was Avery Becker, and 1 story of revenge gone wrong. Opposing counsel was right. This is an easy conclusion. The defendant is guilty, and that is plain to see because of all of the evidence we have used in this case today. I ask that you find in favor of the prosecution and find the defendant, Avery Becker, guilty on all charges. Thank you.
Great, thank you. That concludes our testimonial and argument portion of the trial here today. And it concludes this portion of the mock trial competition.